everyone. My name is Bernard Gluckstein, and as a partner with Gluckstein Lawyers, we are pleased to honored to host our second annual Medical Malpractice Conference called Risky Business. The theme of this year is navigating challenges in medical malpractice cases. Medical malpractice cases are extremely complex and not for the faint of heart. It is probably the most high-risk, high-stakes area of law in which most personal injury lawyers refuse to participate. Among the challenges are the staggering costs of financing, the many years it takes for resolution, and the daunting task of going against well-funded and trial-experienced defense lawyers, who very seldom are interested in settling short of trial. We're excited about the addition to our firm of both Richard Halpern, who is one of the most experienced medical malpractice lawyers in Canada, along with Ottawa's senior counsel, Derek Nicholson. We now can boast that we have one of the best, if not the best, medical malpractice teams in the country. The wealth of knowledge now in our firm goes a long way towards providing proper representation to those who suffer from medical negligence. For instance, a child born with cerebral palsy requires lifelong care and onerous costs, most of which is not funded publicly. We wanted to create a conference to share our knowledge and expertise to others, including personal injury lawyers who represent both plaintiffs and defendants, along with healthcare professionals, doctors and others who are involved in the field. We have tried to cover something of interest for everyone. Hopefully we've done so. Enjoy the day.
Good morning, everyone. I am Charles Gluckstein, and I, with my dad, want to welcome you to a day of learning. It is going to be an exciting day for both of us, as well as we hope all of you. Obviously, during COVID, we had to change our plans a little bit. We had hoped to do this as an in-person conference in the Niagara region, and the good news is that we are doing it virtually, and we can provide all across Canada access to this presentation. So I want to get the show on the road, and I'm going to just give you a bit of an outline of the day as to the different types of speakers you're going to hear from. So I'm going to kick things off with a discussion about the complications of how to get cases in the door and how to know what cases are good cases versus bad cases, because once you get started with medical malpractice, the price goes up, and it's a very, very expensive process to take these cases through to a pretrial and trial. So I'm going to go through that in my topic. We are very lucky to be joined by Justice James Turnbull of the Ontario Superior Court of Justice, and we're going to hear about the issue of causation in medical malpractice cases tried before him with a jury in Uribe versus Tsandelis. Then we have Richard Halpern, who's going to be speaking on a few topics today. First, he's going to talk about getting to know your case, and you're going to see a deep dive into how he analyzes medical malpractice cases. He's going to be joined by Brenda Agnew, a client liaison in our firm and a former client, who's going to talk about the topic birth injuries, what happened to my baby. Very, very interesting topic for people who have clients that may be attending this seminar, and for explaining to these clients exactly the answers they want to know and how delicate that topic is. Then we move into client management in medical negligence cases, and Jan Marin is going to be our speaker on that topic, followed by hospital records, extracting the data, and both Richard and Janet LeBeau, a law clerk at our office, will show off their skills as to how they dissect the medical records and make sure they understand the case before they meet with experts. Ryan Breeden, a medical malpractice lawyer who works with us and has a Barrie office, is going to talk about getting the most out of expert witnesses, a topic that is near and dear to his heart. And then we have Derek Nicholson joined by Danielle Bartlett, both in our Ottawa office, that are going to both discuss demonstrative evidence in these cases. So we have a full packed day. We're very excited you've joined us. We will build in some breaks, and we hope that you'll give us some feedback as to whether you enjoyed the conference. Thanks for joining us. Well, good morning again, everyone. We're going to get the program started. So I'm going to take you through how we start the cases, and when I mean start, right from the lead that comes in through the internet, et cetera, or a call that comes to our office, and take you through the journey of how that client inquiry becomes an investigation. And that's sort of my presentation, is getting us from what I call the three important introductory phases, which include the call, the interview, and the investigation. And what I hope is that this presentation will give you a good footwork or footing for the next presentations to follow as to what it gets involved. Once we've decided to investigate the case, other presenters are going to go through the client's journey as we decide whether the case is viable. So this will be what I call the initial intake of a medical malpractice case. And the conference is called Risky Business for a number of reasons, mainly though because doing medical malpractice work is an extremely risky proposition, not only for the client who wants to challenge a medical decision that was made by a doctor or hospital, but also the lawyer themselves are taking great risks in taking on these cases. And what I mean by that is the statistics against succeeding are so large that there is a financial risk in proceeding with these cases. So why is it risky? So there are approximately 70,000 medical mistakes made per year in Canada. And that's quite a lot. And just to contrast that, there are about 50,000 motor vehicle accidents in Ontario alone. In Ontario, when you practice in motor vehicle accident cases, as many of the attendees do, there is a $5 billion insurance system that compensates almost every victim of an accident. So if an accident victim comes to see a lawyer, you'll see that most of those victims will get representation because in one shape or another, there will be some form of compensation available to those victims, either through the accident benefit system or the accessing the courts, or both. And so if you contrast that area of practice to medical malpractice, where there are still a lot of victims, there is very little compensation. So if you look at this graphic on the right of the page, you'll see that if we looked at the 1,000 claims that emerge from 70,000 errors, more than half of them are abandoned. About a third of them are resolved. And those resolutions don't always mean a monetary payout, because you may think, well, that's pretty attractive. Many of them are resolved by way of an agreement to dismiss the case. And I would say more than 2/3 of that number. For the small amount that remain, and we're talking a very small sliver of those 1,000 cases that go to trial, and this is across Canada, it seems as though almost 8 out of 10 of them fail. And I would say maybe 75% fail. They're in favor of the doctor. There is so much, such an uphill battle to prove that the doctor made a mistake. And even the ones where the plaintiff is successful, if we say 25% or 20% of the time, more than half of them fail on appeal, and almost all of them are appealed. So the statistics, when you put it all together and you think of the risk involved, it is quite a risky proposition. When you look at the system that is compensating the victims, mainly from the Canadian Medical Protective Association, the CMPA, they have almost a $4 billion war chest, they call it, to defend doctors. And it's important to understand that they are not the same as an insurance company. They are a defense fund, and their defense fund will defend doctors in a number of capacities, but mainly in any kind of civil litigation that they're involved in. And they will defend that doctor's reputation, and the doctor does have input as to whether the cases will resolve or not, because the doctor is consulted throughout the process. A settlement that pays out compensation to a plaintiff often requires the doctor to be automatically reported to the College of Physicians and Surgeons for an investigation, as well as any successful trial. So anyone getting into this field has to consider not just the elephant in the room, but there is an elephant and a mouse game going on between the two medical entities that back doctors and hospitals. So as I mentioned, the Canadian Medical Protective Association is funded mostly by the taxpayer, and it provides the backing to provide legal counsel to any doctor who is brought up in civil litigation. And often they will have very good representation. In Ontario, they are defended by McCarthy's, by Lenzner-Slatt, by Lerner's, and by Gowlings. They also are considered governed by their own group of physicians. And that council that meets has a general counsel at Gowlings in Ottawa that run the decision-making process for them. So any reporting structure requires someone at Gowlings and this council to agree on any compensation or how to defend the case or whether to defend the case or not. Suffice to say that any case that appears defensible by their doctor in terms of the actions taken, that case is going to be going to trial. Contrast the position with the hospital insurance reciprocal, which is a group of volunteer hospitals that decide to be part of this fund. Most hospitals are members. Some hospitals pay privately for insurance, but many pay into this group. And this group is run more like a traditional insurance company in that there is a risk assessment and a pro and con analysis as to whether the case should be resolved or not. The problem is it's very hard to settle a case when you've included both doctors and hospitals in the style of cause. And that's because the doctors are not going to compromise in the same type of manner that the hospitals will. So in taking on cases, it's important to understand what the focus of the case is, which mistake was made. If it is a hospital alone case, that may be a more attractive case for a practitioner to take on because it's not going to have, it will have very good lawyers defending it. Mostly in Ontario, it's Borden Ladner. But the approach from HEROC is different than CMPA, which is more of a scorched earth approach. So you could see that it may be a case that's more resolvable than when you have doctors and hospital or doctors alone. So as lawyers, we get lots of calls. We get many, many calls about medical mistakes. There's 70,000 in the country a year. We take on probably 3 inquiries a day that ask us whether they have a viable case or not. And that's a lot of work. That can work out to 1,000 inquiries a year. Sometimes it's more. I would actually estimate it's more than 3 a day. It's probably 1,500 inquiries a year that we're taking on, and it takes a lot of resources. So you have to be very selective, not only about which cases to investigate, but just which cases you even want to interview. Right off the get-go, you should be able to learn how to select cases and then do a thorough intake before you figure out if you want to do an interview and then investigate the case. A lot of it is you making sure that the victim that's complaining of the medical error is a good fit for your office. We don't want clients that have unrealistic expectations. And oftentimes I walk them through the process of telling them how unlikely the case is to succeed right from the beginning, just based on statistics, and that it is a very much a roller coaster ride where even if they think they have the best case, it could be a sponge that was left in after surgery. It will depend on what the experts say. We are not doctors ourselves. We can't tell them right off the get-go whether their case is a winner or not, but it's a process. And it's a process that will require time, it will require review of the medical records, and it will require expert advice. And experts that are capable and informed on the issues, and experts that the court will trust that are informed on the issues, and that the CMPA would use as well, or HIROC. So we pick experts very carefully, and as a result, many of our investigations turn out to be cases we can't proceed with. And the client needs to know that at the start. What kind of inquiries do we get? Well, this is a list of the most common medical mistakes that we would see in terms of surgical injuries, birth injuries, stroke cases, misdiagnosis cases, surgical infection cases, and you can see how the list goes on. Sometimes it's to do with a medical device. It could be done with the aftercare, and it could be injuries that occur at the hospital in terms of falls that occur and mismanagement of care there. So this is kind of the breakdown of different types of incidents that we will see. We are able to follow the case through our intake process, and we use a case management software called FileVine that automatically has fields that will populate based on how we enter in the data. So if we say it's a birth trauma case, a set of questions will come up, and on and on. And we've organized that over time to make the process as easy for people that are taking the information over the phone to take down as easy as possible. Then we decide, okay, then we do a detailed interview, and that detailed interview has to be someone with some skills in the area. So we have lawyers, law clerks that do these detailed interviews, and they have a background of either working for doctors and hospitals in their previous work experience, or they've been doing it such a long time and they have trial experience that they know the right questions to ask. And that's key. To be able to do a really pointed interview will inform you as to whether this case is even worth investigating, because there's a cost to investigation, and you need to be able to screen out, if you've got 1,500 potential cases a year, we probably pursue about 30 of those cases per year. So it's a very selective process to decide which cases you're going to proceed with. We may take on 60 of them, and after our investigation, we proceed with 30 of them. So, you know, you've got to decide, are you going to invest and how much to invest in each of those cases? And most of the time, the client can't afford your medical opinions. If they can, that's helpful, but most of the time they can't. And you, as the lawyer, are going to have to decide how to finance that. We have the technology and capability to take calls all the time. We have the system set up. There's a web system that we use on our internet web page that uses after hours. We have a call center that helps us answer the calls. They're aware of our software. They use university students, and they're capable of filling out the form. That form is shared in real time with lawyers and law clerks associated with that specialty. So in our office, if there was a case involving a stroke, we would get that to our text on our cell phone, and we'd be able to pick up the interview as the caller's on the call, or we would call them the next day if it's an after hours call. So we can take in that information. It's important to have that technology so the client always knows they can get in touch with you. It happens for our existing clients as well. They can text us, they can go through this after hours system and still reach us. And it'll come to our phones, whoever's responsible for the case. We have a pretty sophisticated workflow that we've spent a lot of time developing, and really this intake process is that first step in the workflow as to how it's delegated in our office, how it's set up the project in FileVine, and how it's tracked. A key thing for a lawyer when you're taking in that many calls is to make sure that there is closure to those calls. Did we decide to investigate? Did we give that potential client advice that we're not pursuing the case? Is there a closure to that lead? We have to make sure that that loop is closed, because these can be very, very, you have to track all the work that you do, and they can be costly if it was an inquiry and there was a limitation period associated with it. So we track every call that comes in, and the people that are doing that tracking are trained to pass that process to the next and along this chain of command, which sort of organizes what tasks get sent to each clerk as the case follows through. So if it was an investigation, there are timelines for the lawyer and the law clerk to collaborate and figure out which experts to use and decide when to, whether we are proceeding with a case or not. If we are proceeding with the case, there are timelines for ordering records, getting further experts involved, issuing the claim, and et cetera. And as you go through this workflow, you get all the different tasks that are associated with it. Obviously, the interview process becomes extremely, extremely important of sequencing the chronology, figuring out the background and the client's version of what happened. So we do a lot of emergency medicine cases, and many of these cases, when you look at the emergency physician's notes, first of all, they're hard to read, but second of all, they may only be 1 or 2 lines, and very little is in there, despite what the patient remembers as what happened. So the history is going to be very, very important, and understanding what happened. Was there a witness there? Was the patient seen with a friend in the emergency room or a family member? And what did they have to say about what happened? We had a case involving epiglottitis, and our client had been seen by her physician who referred her to an ENT. She was having what she thought was strep throat. And they said it was very inflamed, and that, if she had trouble breathing, she should go to the emergency room. That evening, she had trouble breathing. She went to the emergency room, gave a full history of what was done to the nurses. They actually recorded it quite well. And the physician who saw her in the ER didn't read any of the nursing records, took his own brief history, and discharged her with some Valium, saying she was having a panic attack. She collapsed when she got home, and she was unfortunately in a coma and never recovered. And that case centered on a lot about the chronology and the history taking. Obviously, we didn't get it from our client, but her husband was with her the whole time. And all of that information helped support a great result. It's never a great result in these cases, but a successful result for the victim's family in this case. We have to do conflict checks. Obviously, there are many doctors that we will not pursue because of our affiliation with them. Many Toronto university centers that we work with these doctors and use them as experts, and we and do other work with them, that we would never want to breach that conflict. We have to check the limitation periods on these cases. If they come to us very close to the end of the 2-year limitation period, if it's an adult, that's not enough time. These cases take at least 6 months to a year to investigate. We would never want to be consulted right at the limitation period. That's a very difficult predicament to get yourself into. Once the lead is taken in, it's opened up in a system called FileVine, and this is kind of what it looks like at the beginning stage when it's a potential new client. And we track all the information in this intake form. So there's drop-down menus that populate other fields, track the referral source, whether they retained us or not. And once they retain us, we move the phase to intake. And there's an intake clerk that will then open the file, do all the things required, set up the limitations book, put out notice letters, things like that. Not necessarily notice letters for medical cases, but to get medical records. And we send a retainer letter to our client. All of these things then get done. But what's interesting is we will not get retained in the traditional sense by a client promising them that we will issue the claim. Rather, we will start an investigative retainer with the client to promise that we'll do an investigation and we'll inform them of the results. And if the results are favorable, we will then issue the claim. But we do not want to be in a predicament where every time we investigate a case, we're forced to start a lawsuit. So it's very important that in this type of practice, you have 2 types of retainer, an investigative retainer, and then it turns into a full-fledged retainer where we're going to issue the claim. Obviously, at intake, we're flagging these key issues of responsibility of the physician, which we call liability, or what mistakes were made, that who owed a duty of care to the patient and whether that duty of care was breached. It may be the nurse, it may be the hospital in other sense, and it may be the physician. Then can we attribute that that's the mistake that led to the outcome of the patient? So it's one thing that they didn't write down the right data or didn't ask the right questions, but did that lead to the actual harm that was caused? And that's the question of causation, which most of the time will trip up most of the cases that you investigate. And then damages. And damages can be a big driver as to whether you decide whether to investigate the case or not. These cases are insurmountable in terms of the costs of your time and your expert's time to proceed with. So if you have to consider that this case is likely to go to trial and cost hundreds of thousands of dollars to proceed. If someone's complaining of an injury that's likely less than a few $100,000 in compensation, you have to think about whether you really want to take on a case like that or not. So that will come into the valuation in your decision. So standard of care is very important, obviously, when looking at the medical community and evaluating them, whether they had a duty of care and how to evaluate that duty of care to the patient. So there are many different levels of duty of care based on the type of specialty that you are criticizing. So in a medical situation, you have general medical doctors and you have specialists, and then you have teaching facilities that have experts that are known as the top of their field and work in teaching facilities in the city centers. So when you're considering the case, and it's a rural hospital with a general physician that's covering off many different areas, you can't then go to a top institution in a university setting and take a doctor of a specialty and have them critique that care. That is not what the court would accept. They have to match the specialty to the specialty and the level of the institution. So we have the rural hospital sort of setting standard, and then we have that university higher level standard. So if it's a if the injury and the victim is complaining of a mistake that happens at one of the top teaching hospitals, then you would have to match the specialty with another expert from a teaching facility. Versus in a rural community, you would want to match the expert with someone in a rural community. So many times we'll have a patient come in, miss a late diagnosed cancer case, and they'll say, you know, I'm now being treated at Princess Margaret, and they said that this should have been seen earlier and caught earlier. But again, an oncologist is not going to be, a general physician is not going to be held at the level of an oncologist. And you have to match whether it was reasonable for a physician, a general physician, working in a community setting to have been able to diagnose that tumor, for instance, at that stage. And that's the level of care you have to match. So if you do find that you have expert opinions that are willing to criticize that expertise, then you've been able to handle that issue. Of course, the medical community, the CMPA, is going to come up with dozens of expert reports to match your one to say that that there was no mistake made. You have to be prepared for that. And the same with the hospital. You can get a nurse expert. There's many nurse experts that are very qualified to give these opinions. And similarly, the hospital will match that with many, many other nurse expert opinions. But what I find trips up most of these cases is the proof relating to causation. That is, did the mistake cause the outcome? So, you know, you'll have we can go back to the late diagnosis of cancer case and ask the question, had that doctor picked up the tumor at that stage, would this person have not still suffered from the cancer? And so, you know, what were all the options available at that stage of their cancer? So, and many times the answer is it may not have made a difference. And so causation ends up being a very scientific question that you may need pathologists involved in neonatal cases. You need neonatology and neuroradiology and all sorts of expertise involved to understand the timing of the injury and whether intervention at that stage, at the time when you think the error occurred, would have made a difference. So this ends up being a very scientific question. No lawyer can answer these questions. You need to spend time with your experts and go through these issues very carefully in order to give your client the answer that they need. When we evaluate damages, these cases are driven by that. So general damages, we are limited to the cap that was set in the late 70s. Many of these cases will involve a loss of income claim that may not be that controversial. What ends up being controversial is the cost of care model that you put forward for your client. So in a compromised or neonatal injury case, cost of care can be in the tens of millions of dollars as you're trying to assess the amount of care that child needs for their whole life. And many of those cases, if it's, we've done cases involving cerebral palsy, kernicterus, hypoglycemia, and essentially, you may have almost a normal life expectancy, and you're talking about, 70 plus years of care. And the care model, if it's 24-hour care, can be over $200,000 a year in care. Add inflation and add that many years, you're into tens of millions of dollars. Other things that go into cost of care are all the medical costs, all the therapies that are required, medications, devices, home modifications, etc. Family members have the ability to make claims for what they have done for their loved one. So past attendant care that they've provided, they may have lost income, and of course they have their own claim for loss of care, guidance, and companionship. And then OHIP is automatically subrogated. So they may have a large claim depending on how long the patient stayed in hospital after the incident occurs. So The technology, once we've gone through it, has an automatic sign-up process. We put the retainer, the investigative retainer, through our system, and it automatically populates the information into the document. It gets sent out to the client digitally and comes back with an authorization. The signed document comes back and then a verification that it works. So that's very good in COVID days to have this technology working. It's very much like DocuSign. So FileVine has an integration called VineSign, and it's basically the same technology and works very easily with getting authorizations to get medical records and things like that. Of course, once we get the medical records, we start the investigation, and the first part of the investigation is to organize and put the records in the right order. So really, when you get records from a hospital, we never get records from the doctors, it always comes from the hospital. It's basically, some hospitals have no policy of how to organize their records. So it's just whenever people filed their forms, it gets just stacked together in a big mess. So our law clerks spend days organizing these records and putting them in an order that makes sense chronologically. And then they will often sort the records in a way that an expert could review it. The last thing we want is an expert to look at 2,500 pages of records. We want to pull out the key records that expert needs to look at. What are the records involving the emergency visit? We don't need to see all the care that occurred after they were admitted to intensive care. The experts on these issues is not going to need to see that. They're going to have to just see what are all the orders that happened around the emergency room, the labs, the results, the CTs, all of that information in chronological order. And we'll do that for them and really make their life a lot easier and make our life a lot easier, because as we get ready for meeting with the expert or doing discoveries, we will have a key document brief that helps us understand the proper chronology and basically jump around the documents in a more efficient manner. And then it's time to pick the expert. So, we have to really get the right expert. And this is not a type of field where you're just trying to find someone who supports your theory of the case. You really need to make sure you have a winning theory of the case. This area of practice is fraught with so many pitfalls and dangers that you want to make sure the expert you pick is someone that the court and the lawyers for the doctors and hospital will respect. Because if they don't see an opinion that has the weight that it should have, then they will not take this case seriously. And you will be at trial and the judge will have the same view. So you have to have a doctor that's credible, that has a great reputation, they don't necessarily have to have been in court before. In fact, many of the experts we will bring out are just top experts in their field and they don't have a lot of court experience. That's okay. The challenge is going to be how they write their medical legal report. And that can be because they're so used to writing scholarly articles and working in the university setting, they may not be used to writing a medical legal report. And obviously, it will take some time to educate the expert to make sure they understand how to write those reports. But these experts can be very valuable. And it's always good to have a fresh set of experts as you move through your career with these cases. It's not a great idea to always fall back on the same people every case you go to. It's good to have some people to consult with to understand your theory of case, but as you get ready for trial, you may want to double up on your experts and have someone that's a leading physician in that area, even though they may not have the court experience. As long as they can eventually write the report that's useful for everyone to read. And then, of course, we get to the point where we are ready to meet with the client, tell them we've done our investigation, and this is the result of our investigation. So that is, in a nutshell, the process for us to take on the cases and decide whether we're going to take the case or not, how we're going to investigate it. And then I'm not going to step on the toes of the other presenters, because the investigation is a lot of where we just make those decisions. And I know you'll be hearing from great presenters throughout the day about how it is in some of the areas that we practice, and decide how we decide how to prosecute a case or not in this area. So thank you for your attention. If you're interested in any of the technology that I discussed, please feel free to write to me. If there's any other questions, there will be an opportunity for you to do a evaluation and let us know what other questions or information you need. I really appreciate you attending today, and thanks for listening in.
Well, good morning. Thank you for inviting me to participate in the Risky Business Conference this morning. And thank you, Charles, for your opening comments and thoughtful comments. I've been asked to speak about causation in medical malpractice cases and some other thoughts. And in starting, I'd just like to thank the law clerk to the Superior Court of Justice here in Hamilton, Matthew Moser, who has kindly assisted me in the preparation of the PowerPoint presentation, which I'm going to use as I address my comments to you. I think in an audience like this, it's hardly necessary to say that medical malpractice cases and the misadventures associated with them affect the whole family, physically, emotionally, and financially. I can say one of the things that most deeply concerns me as a judge is the significant delays in getting these matters to trial and the absolutely extraordinary costs associated with retaining experts, retaining counsel, doing discoveries, and going through the whole gamut of interlocutory motions and procedures and pretrials to get the matter to the courtroom. I simply would say, collectively, we need to do much better. We need to consider, in a more aggressive way, the bifurcation of trials, the settlement of damages, ways to reduce the time and stress on the parties. And we need always to be mindful of the fact that in every one of these cases, there's someone who has been injured or hurt or died who needs to be cared for financially and by the rest of the family. That has to be central to what we do. And so I urge everyone to collectively put your thinking hats on, just as the court has had to start to put its hat on with respect to improving electronic communications because of the pandemic. We need to put our hats on to find ways to make access to justice quicker and more affordable for everybody. In this matter, I'm going to frame my discussion relative to causation around a trial that I presided over before a jury last year. In a nutshell, it involved an allegation of negligence in the delivery of a little baby boy, Elijah Uribe. And by the time of trial, I believe he was 10 years of age. So a lot of time had passed in between the time of the misadventure and the start of the trial. In this case, the obstetrician and gynecologist was sued, and the nurses in the hospital were also added as defendants. The defendant, physician, claimed over against the hospital and the nurses. The matter was tried before a jury. Counsel for the plaintiff and the defendant doctor agreed on damages. So the sole issue was liability and causation. And before trial, the plaintiff entered into a parentage agreement with the hospital. In other words, the hospital settled with the plaintiff for an undisclosed amount that I never knew. The action against the hospital was not proceeded with by the plaintiff, but of course, the cross-claim by the defendant doctor against the nurse and the hospital continued. The issues in the case, in a nutshell, were the standard of care, causation, the jury verdict, and apportionment of damages, and then ultimately a Rule 5208 motion. I would say to counsel that before I get into the details of the case, the lawyers in this particular case followed a really important golf lesson that somebody recently taught me. And that lesson is simply this: I'm not a good golfer. And my friend said, if you want to improve your golf game, what you've got to do is quit playing golf from the green, from the tee to the green. But instead, you need to start to play the game from the green to the tee. In other words, find out what distance you need to have the ball so that when you try to put your ball on the green, you're using your very best club. In other words, what are you looking at the end? In this particular case, right out of the gate, the lawyers put a motion before me with respect to the ultimate question to be put to the jury on the issue of causation. I urge all counsel to look at that question right out of the gate. And if there's going to be an issue, discuss it with the other lawyer. And then if the two of you continue to have a difference as to what the applicable question should be, at a relatively early date, make the court aware of that, perhaps at the time of a pretrial. Or earlier than that, contact a trial coordinator and indicate you'd like to bring a preliminary motion before the trial judge. Why? First of all, we don't like to pick juries and then have them sitting around while we're dealing with interlocutory motions. Some of these issues, as you'll see in the motion I had to consider, are complicated. So we need time to assess it and reach a proper decision. Because if we make a mistake on that decision, it may very well mean the Court of Appeal sends it back for a new trial. So what is the question going to be? How are you going to deal with it right up front before we've picked a jury, and so that we don't have jurors sitting around waiting and waiting until that issue is resolved? I'm going to take some time just to go through the fact situation in this Uribe case. In a nutshell, the plaintiff mother was in labor progressing well to about 7:30 a.m. and about 9 a.m. Dilation had remained unchanged. And the defendant physician spoke with the patient and agreed with her request to allow her to try to progress to full dilation so that a natural birth could be given. He returned to his office on standby just 5 minutes from the hospital. And all experts agreed that it was within the standard of care for the physician to return to his office. The nurse, one nurse remained at the patient's side, giving one-on-one care. At 9:52 a.m., about 50 minutes after the doctor had returned to the office, the baby had a significant heart rate deceleration for approximately 5 minutes. The nurse assessed Mrs. Uribe and employed standard resuscitative maneuvers. And so after 5 minutes, the heart rate returned to normal baseline. The nurse then called the doctor to advise, and the exact time of the call was unknown, but it was probably 10:03 to 10:05 a.m. And she advised Dr. Tsandelis that the heart rate was then stable. Dr. Tsandelis advised the nurse to call him immediately if there was another deceleration. And he remained at his office to see 1 or 2 remaining patients and instructed his staff to cancel all other appointments so he could return to the hospital. At approximately 10:17 a.m. to 10:18 a.m., there was another deceleration of the fetal heart rate. The nurse again assessed the situation and again employed standard resuscitative maneuvers. At 10:20 a.m., the nurse did a vaginal examination and found no evidence of meconium. For those who aren't familiar with the issue, meconium is baby poop, and it means if it's present, the baby is in some distress. But there was none evident at 10:20 a.m. From 10:20, the fetal heart rate continued to decelerate, and at 10:25 a.m., the nurse performed another vaginal examination. meconium was present. All experts agreed this was indicative of a total occlusion of the umbilical cord, cutting blood and oxygen supply to the baby Elijah. The nurse called Dr. Tsandelis at approximately 10:27 a.m. Dr. Tsandelis was already driving to the hospital when he received the call. The hospital's labor and delivery unit only had 2 operating rooms. Elective C-sections that day were typically scheduled at 9 a.m., 10:30 a.m., noon, and 1:30 p.m., alternating from one room to the other. Dr. Tsandelis testified that the patient for the 10:30 a.m. elective procedure would have been taken to the operating room at approximately 10:20 a.m. to prepare for delivery. When the total occlusion of the umbilical cord occurred at 10:25 a.m., one operating room was not available because it had not yet been cleaned after a prior procedure. The other room already had a patient in it. That is the patient for the 10:30 a.m. elective procedure. This patient needed to be moved and the room sterilized before Mrs. Uribe could be taken into it. The nurses did not move Mrs. Uribe to the operating room then until 10:34 a.m., and she was in the operating room at 10:35 a.m. The nurse testified that Mrs. Uribe was moved to the operating room as quickly as possible. Dr. Tsandelis testified that when he arrived at the operating room, other members of the clinical team were not ready to perform the C-section. Dr. Tsandelis was in the operating room applying a fetal scalp clip at 10:40 a.m. The anesthetist started the anesthesia at 10:40 a.m. The C-section could not proceed until Mrs. Uribe was properly anesthetized. Of course, the special care delivery nursery team was present at 10:45 a.m. The C-section began at 10:48 a.m. and 1 minute later, at 10:49 a.m., Elijah was delivered. The nurse testified that at 10:49, it was the earliest possible time that Elijah could have been delivered. Upon delivery, Elijah was resuscitated and taken to the NICU. Dr. Tsandelis had no further involvement in his care. And tragically, today, Elijah suffers from severe cerebral palsy and other medical conditions. So I'll deal first with briefly with the standard of care issues. The main standard of care issue was how Dr. Tsandelis responded to the phone call he received from Nurse Nicenin following the deceleration, the first deceleration that occurred between 9:57 a.m. and 10:02 a.m. Specifically, 1, whether he should have immediately returned to the hospital to assess his patient. 2, whether he should have told the nurse not to restart oxytocin. It's a medication given to increase contractions to assist in delivery. And thirdly, whether he should have directed the nurse to immediately make arrangements for an emergency C-section in case it was necessary upon his return to the hospital and his assessment of his patient. The guidelines of the Society of Obstetricians and, I've repeated myself, Obstetricians and Gynecologists of Canada, SOCG, specifically provide that in the event of a single prolonged deceleration of the heart rate of the baby for more than 3 minutes and less than 10 minutes, preparations for delivery should immediately be undertaken. So the issue was, did the doctor's response fall below the standard of care? And the second issue, of course, was did the nurse and or the hospital's response fall below the standard of care? The jury's answer was yes to both defendants. The issue of initiating the reservation and preparation of the operating room for an emergency C-section during the phone call with the nurse was not canvassed by any of the experts in their reports. I asked a question of the nurse and 2 of the experts at the end of their testimony. Counsel for the defendant didn't object at any time. The issue is, should he have? And we have to consider what's the role of the trial judge. On the causation issue, a motion at the outset of trial to determine the question of causation was held. The position of the plaintiff on the question of causation was as follows. If your answer to question 1 is yes, that is a breach of the standard of care, have the plaintiffs proven on a balance of probabilities that Dr. Tsandelis' breach of the standard of care caused or contributed to Elijah's injuries. The emphasis added is caused or contributed. And the position of the defendant was, if the answer to question 1A is yes, had the plaintiffs proven on a balance of probabilities that Elijah's brain damage would not have occurred without that breach of the standard of care, i.e., but for that breach of the standard of care. The plaintiff's submissions on the causation question relied on the recent Court of Appeal decision from Ontario, Sachs versus Ross, which affirmed the use of the terminology caused or contributed to in medical malpractice cases involving multiple tortfeasors. And they further directed me to the decision of Cheeseman et al. Versus Credit Valley Hospital, and where one of my colleagues, Conan J., also endorsed the use of caused or contributed as the appropriate charge. Their position, the plaintiff's position, was that in the current case law and in the case before me, the alleged negligence of the various defendants overlapped. And this may cause the defendants to point the finger at each other, thus escaping liability. The defense argued to the contrary, stating that the Supreme Court of Canada wording in Clemens versus Clemens that confirmed the but-for test, it is the appropriate test in most cases, and urged me to recognize it should only be departed from in exceptional circumstances. The material contribution test may only be applied where it's impossible for the plaintiff to prove the defendant's negligence caused the injury on a but-for standard. And a further case was referred to me by the defendants where their argument was supported. The ruling I made on this case is cited in the slide before you. And at paragraph 15, I determined that in the factual matrix of this case, the Sachs approach upon which the plaintiff urged the use of causal termination of causing or contributing is not required. In my view, the factual matrix is not so confusing that the conventional but-for test cannot be applied in this case, even though there are multiple defendants. Hence, I determined that in the case before me, the jury will be asked, depending on the answers given on the standard of care and causation, to allocate a percentage of liability to each party. They will understand that it's open to them to find contributory negligence if they consider it appropriate on the evidence. In my charge to the jury, I can explain that it's open to the jury to find Dr. Tsandelis' breach of the standard of care may not be the only cause of Elijah's brain injury, and the jury is allowed to conclude that the nurses enter the hospital also caused the child's brain injuries. They will see from the questions given to them that if they find both parties did cause damage, they'll be obliged to allocate the degree of responsibility. And so I've just laid out here at the next slide the questions that were put to the jury in this case. Question 1A was the breach of standard of care question. So if they say yes, there was a breach of standard of care. Question 2A is, have the plaintiffs proven on the balance of probabilities that but for, those are the operative words, the breaches of the standard of care for Dr. Tsandelis, Elijah would not have suffered brain damage? They answer yes or no. And then at paragraph 2B, which became contentious, and you need to be aware that there's an alligator lying in the woods there. The next question was, if your answer to 2A is yes, please provide clear and specific answers as to how the breach of the standard of care caused the brain damage. And similarly, with the nurse and hospital, the same questions were applied and using the same terminology. The jury in this case returned an interesting verdict. They apportioned liability between the parties as follows: 32% for the defendant, Dr. Tsandelis, 68% for the defendant's nurse hospital. With respect to the question about Dr. Tsandelis, the jury answered yes for the but-for question. In response to question 2B, where the jury was required to explain how his breach of the standard of care caused Elijah's brain damage, the jury wrote, Dr. Tsandelis' failure to follow the SOGC guideline, prepare for delivery, contributed to Elijah's eventual brain damage. I've underlined and emphasized contributed to. The relevant extract of the SOG guideline provided that in the event of a prolonged deceleration of more than 3 minutes and less than 10 minutes, the physician should take immediate steps to prepare for delivery. With respect to the nurse and hospital, the jury responded, you'll see in the last bullet point, Nurse Nysanen, that's the nurse who was giving the one-on-one care prior to and at the time of the decelerations, didn't follow the SOCG guideline, prepare for delivery, at the time of the first deceleration at 10:02. And this caused a domino effect. And therefore, I underlined the word caused. So the issue is on the motion that came before the court, and what will be an issue in the case that you take to trial. If you're trying it with a jury, and in fact with a judge, is it the Clemens but-for test or the Sachs cause or contribute to, which is the test? And interestingly enough, recently in the case of Dubé versus Fu, a decision of the Superior Court of Justice, one of my colleagues, the trial judge concluded at paragraphs 24 and 25. In the present case, the claims against the physicians, so in this case there were multiple physicians, the hospital, and the agency nurse were not based on discrete factual situations. The plaintiffs allege that the injuries occurred as a result not only of the defendant's individual breaches, but of their failure to work together as a team. As such, the caused and contributed language was appropriate. Thus, the language recommended by the Court of Appeal in Sachs of caused and contributed was used, and it was the judge noted it had been effectively affirmed by the case of St. Joseph's Hospital in Hamilton at the site noted. That was a judge alone case. So I would say the causation question for dummies, and that's for me, is where there is one or two defendants and relatively discrete acts. The but-for test is the law. But where there are multiple defendants and any one of them may have caused or contributed to the injury, the use of the cause or contribute wording is the law of Ontario. And I would draw your attention to the fact that the Sachs decision went to the Supreme Court of Canada and leave was refused in that case. The citation for that is found in the notes that will be distributed to you of my talk. When the jury's verdict was received, counsel for the defendant indicated that he wished to bring a motion pursuant to Rule 52.081 of the Ontario Superior Court Rules of Practice. I imagine similar provisions exist in other provinces across the country. The basis of his motion was that where the jury, under Power Point 2, makes no finding on which a judgment can be granted, or Point 3, that it gives conflicting answers, the trial judge may direct the action be retried with another jury or at a subsequent settings, where there's no evidence on which a judgment for the plaintiff could be based. And that was the basis of the motion. And I've highlighted here the provisions of the Courts of Justice Act, the Rule of Civil Procedure, and those were the two legislative bases upon which the motion was brought by the defense. I was advised the legal test for a judge to follow when dismissing an action under this rule was set out by my colleague Casey J. of the in Hill versus Church of Scientology of Toronto. A trial judge may refuse to accept the verdict of a jury only when she or he considers that there's no evidence to support the findings of the jury, or where the jury gives an answer to a question which cannot in law provide a foundation for a judgment. In this case, the defendant argued the jury used the word contribute in giving its reasons, which indicates they didn't apply the but-for test. In other words, in answering the questions relating to the causation component relative to Dr. Tsandelis, in the answer, they used the word contributed. And they argued there was no direct evidence led that even if Dr. Tsandelis had attended at the hospital immediately after receiving the phone call about the prolonged deceleration, that a delivery room would have been available. And in its answer to question 4B, explaining how the nurse hospital breached its standard of care, counsel for the defendant emphasized that the jury used the word caused, not contribute, thereby confirming that the jury used the correct test in answering that question, but erred in applying the incorrect test when answering question 2B, when it used the word contributed in describing the actions of Dr. Tsandelis. The motion was dismissed for written reasons found at the citation. In doing it, I wrote, their answers must be read in the context of the case and the task they were undertaking. They were fully aware that depending on their answers, they'd have to apportion liability between Dr. Tsandelis and the hospital and nurses. They did that when they apportioned 32% to Dr. Tsandelis and 68% liability to the hospitals and nurses. The fact they used the word contributed in explaining their answer to the causation question is not indicative of their failure to apply the appropriate but-for test in answering the causation question. The jury found that both the defendant and the settled defendants caused the damage. If the courts hold the members of if the courts hold the members of a jury to the same standard of perceived legal perfection in terminology as a judge, it's questionable if the explanation for an answer given by a civil jury would ever meet the standard sought by the defendant. And the motion was dismissed. I refer to this fact in this particular case because I urge counsel to recognize this eventuality, whether you're acting for the defense or the plaintiff, depending on the verdict, is possibly going to land on your lap as soon as the verdict is received. I urge you to have a copy of the rule and some relevant case law available for the judge. After the verdict is delivered, ask the trial judge for some time to deliberate with your client and or your colleagues in order to determine if a motion should be brought and how it should be brought. And if you feel a motion is justified, ask for time to prepare arguments and a factum, and I think most times a judge is going to grant that request. Understand that the bar is high for such a motion to succeed. From a practical point of view, many of the arguments made on this motion will be the ones made on an appeal. Will a judge want to easily call a mistrial with all the attendant costs and time thrown away? Will a judge prefer to leave the matter to the Court of Appeal? If you don't bring such a motion, is your client prejudiced in the Court of Appeal? These are issues that you need to consider. From Uribe versus Tsandelis, the case, I want to just offer you some what I call practice tips that I offer from the point of view of a judge who presided over the trial. First of all, be prepared. As I said, this is difficult, expensive, and important litigation. I can say without overstating it, the lawyers who appeared before me on this case were very prepared, extremely qualified, and did a wonderful job. Carefully consider what witnesses you need to prove your case. Very interestingly, in the Uribe case, the counsel for the defendant, Dr. Tsandelis, proved the negligence of the nurse and hospital through the examination and cross-examinations of the experts who were called by both parties and the nurse. He chose not to call any witnesses or experts on his own behalf other than what he called in the course of presenting his defense on behalf of Dr. Tsandelis. It was a very interesting and successful strategy. And counsel always need to consider what are the pros of calling a witness and what are the cons. And unless there's an advantage, it most often is in a best decision to leave the witness off the stand. In this particular case, the fetal heart monitoring strips were important to be able to show the jury moment to moment the decelerations and recelerations of baby Elijah's heart. And those charts are quite voluminous. I urge counsel, number the pages. And secondly, have one of those light pointers available to be able to highlight the spot on the screen indicating the point on the monitoring strip you're referring to. The jury will be sitting in the jury box, and if the heart monitoring strips are projected on the screens, it's important to easily find the pages. The judge needs to do that, and counsel need to, and the jury needs to know and be able to follow exactly where you are. I urge you to be prepared, of course, and a detailed order of proof is critical. An order of proof, of course, is each element of the case and how you're going to prove each part of your case, down to the last cent of damages if you've got to do it. I urge counsel all the time when I'm speaking to young counsel to keep your order of proof foremost in mind every step of the way. It's your game plan. It is, and you build on it and build on it until you've covered every element of your case. Please provide the trial judge, if possible, with a copy of your opening statement, both in a jury or non-jury case. Those statements are like the front of a jigsaw puzzle, the box. You look at the front of the box, you know what the puzzle looks like. Getting an opening statement, not having to take notes, but being able to know what the puzzle is going to look like when the case is finished is really helpful to the judge and to a jury. If you get to written arguments, particularly in judge-alone cases, provide a copy of your, if you get to arguments which aren't written arguments, but you've reduced your arguments to writing, even in point form at the end of the trial, please give a copy to the judge. Take a note. If the judge is right-handed, then keep the right third of the page blank so she can make notes as you're going through your submissions. I urge you, try to avoid a judge insisting on written submissions, if at all possible. The time required to do them properly and the associated costs are prohibitive. Furthermore, submissions are best done while the evidence is fresh in everybody's mind. And that can't be done in every case, in long, complicated cases. But I do urge you to do the submissions as close as possible to the conclusion of the trial. I remind everyone a chart or a picture is worth 1,000 words. In the particular Uribe case, which is a good example, where we have a compromised child and where the child's not able to testify, in my view, it's not inappropriate to introduce the child to the court or the jury on the opening day, maybe in opening statements. There's no need for the child to spend more time before the court. In that way, it was done in the Uribe case. It was done appropriately and tastefully. And I'd urge you to work with opposing counsel to prepare a joint document brief in advance and work out how that brief is to be treated by the court. First, is it proof of the contents? Secondly, are only the documents identified during the trial to be considered by the court in rendering a judgment? That, of course, would be more difficult with a jury. Thirdly, do original documents need to be produced? Fourth, is a document brief to be entered as an exhibit or simply as an identification exhibit and reference made to particular pages, which then become exhibits. And last, please number every page in a document brief consecutively and in the same place on each page, even if there are tabs A, B, C, and D in it, etc. Number the pages. And finally, when you're examining a witness, remember that you are the conductor of an orchestra. And what I mean by that is simply this. As you stand at the podium asking a witness a question, you need to keep the jury, which is to your side, in mind. You need to slow down and remember that jurors probably walk, don't run. They don't know the case as quickly, they won't know the case as well as you do and be able to move from point to point as quickly as you. And secondly, you also have to keep your eye on the whole orchestra as the conductor. Keep your eye on the judge. He or she is going to be taking notes because he or she, if it's a jury case, is going to have to do a summary of the evidence, the pertinent points in the charge to the jury. You want the important points to be given to the jury by the judge, and if he misses them or she misses them, then what's the use of asking the questions? So keep your eye on the judge, and when you see the judge is finishing writing, move to the next question. Wait for the judge. Keep the jury in mind. You're directing an orchestra. Whatever you do, don't bicker with opposing counsel. Direct all your concerns or objections through the judge. Be on time. In fact, be early. If the judge takes a 20-minute coffee break, be back in 18 minutes. If we're going to resume at 2:15, be back at 2:10. If you plan to use any type of technology in the trial, I urge you to do a dry run beforehand, because if something can go wrong, it will go wrong. Somebody once said, a good trial lawyer knows the law, a great trial lawyer knows the judge. Once you know who the judge is, speak to your colleagues about any idiosyncrasies he or she may have. Check some of their decisions. I urge you to know your judge, if possible, because it's going to make the trial go easier. One question that arises from time to time is whether the judge should give his or her charge in writing to the jury. You might want to ask the counsel that. In the Uribe case, I did do a charge to the jury. I gave 6 or 7 drafts as it developed to counsel to review during the evenings, and ultimately the full charge, including the law and my summary of the evidence, was given to the jury. You want to know this at the outset of trial, so there's time to review and vet the charge. And there are pros and cons. Sometimes people feel the judge's summary of the evidence emphasizes the evidence for one side too much or the other. Is the evidence summary complete and accurate? Will the jury rely on the judge's summary of evidence rather than their own recollection? And should just the applicable law be given to the jury? Those are questions for counsel to raise between themselves and with the judge. I can tell you that on a personal basis, in doing criminal and civil cases with juries, the response of the jury to being given the entire written charge is overwhelmingly positive. They indicate that when there are questions that they have relative to the law, it's easy for them to find the appropriate law and apply it. I can say in a criminal context, when I've done it, there are very few questions from the jury which come back after they've gone out for their deliberations. Briefly, your closing address to the judge and jury. I urge you to get to the point and skip all the niceties. So often I listen to counsel get up and talk about the fact that Justice Turnbull is the judge of the law and you take the law from him, that what you've got to say is not the law and so forth. You don't need to say all that stuff. I'm going to say it. The judge is going to say it. Get to the point of your case. American Bar Association a number of years ago, I guess they interviewed a number of jurors and then I guess they observed some jurors. And they said you've got about 20 minutes to get your point across. And then the attention span starts to drop off. So I urge you, start with a clear, simple statement and finish with it. Example, we wouldn't be here today, members of the jury, if lawyer X had simply followed the written, clear guidelines of his professional governing body. That's what this case is all about. There it is. There's your argument. Some of you might be old enough to remember the late Johnny Cochran in the O.J. Simpson case. And he got up before the jury. His opening comment was, holding the glove up with dried blood on it that O.J. Simpson had tried to put on after being asked to do so by a rookie lawyer who should never have asked the question. If it don't fit, you got to acquit. And the case was over. Finish with what you start with and get to the point. Keep it concise as possible. I just briefly want to refer to the fact that with the pandemic we're facing, Zoom has become a platform, quite evidently by today's discussion, that will have to be considered by counsel. Zoom medical malpractice trials are upon us. Until recently, I was scheduled to start a Zoom medical malpractice trial where all witnesses and all evidence and all submissions were going to be done on Zoom. This is increasingly going to be the case. You need to discuss this early on with counsel and with the trial judge or a trial management judge. And I urge you to get contact a trial coordinator to get a judge, whether a trial management judge or the judge who's going to do the case, involved relatively early. And I'm not going to take you all the way through it. I've just attached some considerations to be canvassed in such a call. From an endorsement prepared by my colleague, Justice Sanfilippo in Toronto. And I just cut and pasted it for ease of reference. It was provided to me recently to assist me as we were going to do our MedMal case on Zoom. And so take some time and go through that, because the judge has really taken a lot of time and had input from counsel to give a lot of helpful suggestions and directions to make a MedMal trial on Zoom work as effectively as a live in-court trial. And I think what a lot of us on the bench are finding is that Zoom is working remarkably well in many, many, many more procedures than we ever anticipated. I'm encouraged by it because it just seems to me that not only can counsel work effectively from their offices using the technology, but the costs of traveling for witnesses and for counsel to and from courthouses each day, it will significantly reduce the costs for people seeking access to our judicial system. So that pretty well concludes what I've got to say with respect to this matter. I trust that it's been of some interest to you and maybe of some help to you as you move into the next medical malpractice case in which you'll be participating. So once again, to Charles and to the Risky Business Conference people who invited me to speak, I thank you for allowing me to participate and wish you the very best. Thank you.
Hello, everybody. It's Richard Halpern again. I'm glad to be working with Janet LeBeau at Gluckstein Lawyers on a lot of medical malpractice cases and to talk about hospital records and how we extract the data. Janet has worked closely with me in analyzing records and then using what we prepare in that analysis to meet with our various experts and our clients. So Janet, I'm going to hand it over to you.
Thank you, Richard. I'd also like to say it's a pleasure to work with Richard on these cases. I've learned a great deal from him in the short period he's been with us, and I look forward to learning more. One of the things that we particularly wanted to address today is about the hospital records and extracting the data. This may seem like a very basic element of a litigation case, but it really is incredibly integral in the investigation and then with working your case using all these records for future discoveries and pretrials and trials. So one of the things that we have to make sure we do in these medical negligence cases or particularly with our birth trauma cases is to make sure you've collected all the relevant records. For example, as I said in the birth trauma cases, we need to make sure we have all the antenatal records, including the ultrasounds. This is important to establish whether or not there was a normal pregnancy or if there were indications for follow-up and or treatment during a pregnancy. For example, if there was something on the ultrasound that was not noted, then we would actually get the ultrasound imaging itself, not relying just on the reports, and have an OB with experience in reading the ultrasounds and reviewing and providing opinions as to what was missed or not missed. We also would often will get records with respect to previous pregnancies. This will establish that the mom has in the past delivered a healthy baby, or if in fact there were problems with previous pregnancies and extra attention may be required during these subsequent pregnancies. We need to get, seems very basic, but all the labor and delivery records. So that means get all the fetal heart tracings. We always like to get a hard copy, specifically the continuous paper tracing. Fetal heart monitor tracings are presented in two formats during labor. Electronically, which can be seen in real time anywhere accessed in the hospital, for example, the OB's office or the nurse's station. And also it's the paper tracing will be with the electronic monitor that's actually in the room with the mom. We want the benefit of being able to see what the doctor sees and also what the nurse sees. Often there's a conflict there or inconsistency. Color copies. Much of the charting is still handwritten, and seeing different colors in the handwriting can be helpful in identifying who and what has been written. We also like to get hard copies with respect to the chart, but that's not always possible. So we make sure you request a color version of the electronic records, and then you can print it off yourself. We also get all newborn records. The baby has a chart of his or her own. This has to be requested separately. If you're requesting records for the mom, you may not get the records for the baby. So make sure you get baby boy, baby girl records as well. Included in these newborn records are the pathology reports, the lab results, imaging, genetic testing, and you need to get the actual imaging, not just the reports. You will need a neuroradiologist to review this neuroimaging, and that often what they find doesn't fit with the impressions in the report you have in the records. But that just means that the staff radiologist may not be looking for what you need your expert to look at. There are other cases where, of course, it's very important to get additional records. And for example, delayed diagnosis cases. It will be necessary to go as far back as you can, especially in cancer cases. This will include family physician records, as well as hospital records and all imaging. We review all the pre-existing conditions. We review for the adequacy of prior assessments. Was something missed? Again, it's very important to get the color copies. It just makes a big difference in reviewing. So why do lawyers and law clerks need to extract data from medical records? First of all, we need to determine the factual foundation of your case. You prepare a thorough chronology of clinical events, and that is helpful in dealing with experts and preparing for discovery. You'll be able to identify the issues in your case by having all the pertinent records available and being able to review everything. Discoverability. When is your limitation? Sometimes it's not always consistent with what your client has told you. This will allow us to address and clear up these discrepancies. Sometimes the client's incorrect, sometimes the records are incorrect. So also, it's very helpful to get all the records and make sure that you've gone through everything in detail so that you're able to prepare a thorough chronology of clinical events. This is helpful in dealing with experts and preparing for discovery and pre-trials and trials down the road. Preliminary research into the issues of standard of care and causation. So you're able to go through the records, and there'll be maybe more than one area where there's an issue of the standard of care being breached, and you also need to identify where there are perhaps problems with your case and causation. You're also, by going through the medical records, you're able to identify the medical discipline that might be required to prove your case. Do you need an ER doctor? Do you need a radiologist? It's very important to go thoroughly through the records to see what might have been missed. You may need to get, certainly in baby cases, we get experts from various different disciplines in order to prove the standard of care as well, and particularly to prove the causation in these cases. The records and the chronology will allow you to formulate the questions to pose to your experts. When you meet with your expert, you want to be able to be as informed as you can, so that you can see that they've been informed and they've gone through all the records, and that you're able to have a thorough understanding of what they think has gone wrong, or what they think has led to what has gone wrong. Richard, there's several times that you and I have met with experts, and you've done a very thorough chronology, and we've reviewed the records really well. What would you say is one of the most important things when you're meeting with an expert and using the records and the chronology?
The records that we get in these cases are usually pretty voluminous. Baby cases maybe not as bad as other kinds of cases, but cases that involve, that are complex, that involve long-term care. I've seen 5,000, 10,000 pages of records in some of these cases. And you have to have easy access to the relevant records in order to make your interaction with your expert meaningful. So I like to go through these 10,000 pages or whatever it is, and distill it down to the 200 or 300 most important pages, and then have easy access to the relevant stuff. And I'm later in another presentation, I'll show how I do that. But when we meet with the experts, and Janet, you've seen this when we've met with the experts, if the expert makes reference to some sort of important clinical event that might have occurred, we can quickly put our finger on the reference in the chart to that event, and not only to that event, but to all other relevant events or findings or test results and that sort of thing. It's important to make sure that your meeting with your expert runs smoothly, that you have your fingers on the important data that the expert needs to look at. And it also helps you make sure that the expert has been thorough in her analysis of the case. That's obviously critical to what happens. So the experts like that too, where you can quickly get your hands on the relevant stuff and make the meeting with the expert more productive. And it also demonstrates to the expert that you're familiar with your case and you've devoted some time and thought to it.
Exactly. And I recall a particular meeting that you and I had with a neonatologist where he did a very thorough review of the records, and he was drawing out certain areas of the records that supported his opinion. But you were even to point towards some lab results that were perhaps 2 weeks later that certainly supported what his opinion was. And he had only really looked at the records from the week after the delivery of the baby, and I mean it certainly just bolstered the case. And so it showed our expert that you knew the records as well as he did, or certainly better. So
well, it's important in all of these cases. As lawyers, we invest a lot of time and money in prosecuting these cases. The cases are extremely important to our clients, which is the highest priority. And I think by knowing the records, we can test the veracity of the opinion that we're getting from the experts, but you have to know the records to do it. Part of what we want to do is test whether or not in the final analysis, this expert is going to be believed. Have they been thorough? Or on the other hand, have they missed things that might undermine the report or anticipate the defense? What is the defense expert going to say about the issue that we're talking to our expert about? We want to test those opinions because we want to make them as reliable as possible, because we invest heavily based on those opinions. So we don't just accept an expert's opinion, we test it. And you can only test the expert's opinion if you know the facts and you know the records.
exactly. So there are other considerations in obtaining, reviewing, and how you use the records. And I think I touched on this earlier on, discoverability. The complete records allows you to determine the trigger for the limitation period. Again, sometimes the client has provided you information that is inconsistent with the records. So that's one of the very first things I look at when we get the records is, does it fit with what the client had said, the onset of the injury, essentially when you knew or ought to have known that the negligence took place? Other things in the medical records that we've had to consider recently are the electronic medical records, EMRs, and these frankly have caused more work for all of us than the handwritten notes that we were getting previously. I mean, the nurse's notes used to be about 100 pages long for an average hospital stay, and now they're about, anywhere from 500 to 800, sometimes 1,000. Rarely are they in order, these electronic records, and they're almost always repetitive. You get the same sort of lead up over and over every single day. So you've sort of got to distill everything down and try to extract from those electronic records the important points in order to figure out exactly how the chronology took place. You don't want, as I just said, the importance of going through these records and distilling them is essential to make the experts' jobs more efficient as well. We don't want to be paying them for hours of wasted time going through every single document in the records when there's a lot of repetition and there's, a lot of things that don't concern, what they're going to be considering with respect to the foundations of the case. It's also essential you have all the necessary records that your expert requires, as this will avoid multiple meetings with your experts as well as large disbursements from the time that they have spent. There have been times where I've sent, medical records to an expert and they've said, I need the records from the year before so that I can compare. Really, we should try to make sure that we've done all that ahead of time. It is of complete value for you to be thorough and detail-oriented. And again, as we said earlier, and as Richard said earlier, the importance of condensing the records will avoid you getting bogged down by multiple references to the same document. We're trying to make everybody's job as efficient as possible. And certainly it's, if we're able to get through all of the pertinent information and use everything that is available to us, it makes our job easier, it makes our experts' job easier, it makes proving the case easier. I'll move to the next slide here. So the benefits of preparing a chronology, I touched on that earlier, and Richard touched on that too, is trying to do so as soon as the records come in, so that you're able to condense everything and then create a page reference chronology, which allows easy access. And again, as Richard had said, he's going to talk about how he does that in all of our cases in another presentation. So the benefits of early review and synthesis of the records is that a single document covering records from various sources is a time saver. It allows you to identify issues of the standard of care, identify the issues of causation, preparing for meetings for litigation experts, and preparing for examinations for discovery. Okay, the benefits of early review and synthesis of the records is a single document covering records from various sources is a time saver. It will allow you to identify the issues in the standards of care, identify the issues on causation. It allows you to prepare for meetings with your litigation experts and prepare for examinations for discovery. With respect to the examinations for discovery, this chronology allows identification of possible exhibits for discovery quickly and in the right order. Quick reference to documents ensures the flow of questioning will not be interrupted, which can make your examination for discovery last hours longer than it needs to. And the benefit of creating the type of chronology that we do in these cases is it allows it to become much easier to add records, you know, in preparation for pretrial and trial. I mean, as you know, records are going to be coming in continually, and it's much easier once you have the chronology set up and you've got everything page numbered, and you can just go by the date and then reference the document, and then you can find out where that's located in your brief. And it makes it much easier for preparing for pretrial and then also for preparing trial briefs. Richard, do you have anything else to add? I sort of whipped through some of those things rather quickly.
Sure, Jen. Let me just touch on a couple of issues if I can. One question that might come up in these cases is, how do you know what's important in the hospital record? You're a lawyer, you're a law clerk, you're not a doctor. How do you know what's important? One of the things that I like to do is to research the issue, the medical issues that are involved, and that will help me understand what is important and what is not. Some lawyers like to hire nurses or other medical professionals to go through these large volumes of records and then prepare a summary and a chronology of the relevant records. And while that's fine, to me, it's not an obligation that really can be delegated. If you're the person who is going to be meeting with the client to talk about the issues, if you're the person who is going to be formulating the issues for the experts, if you're the person who's going to meet with the experts, and more critically, if you're the person who's going to be conducting the examination for discovery, you must have a facility with these documents in order to do an effective examination for discovery. You must not interrupt your flow at examination for discovery. You must have quick access to the relevant records at the examination for discovery. And this chronology and this review and synthesis of the records that we're talking about is the critical thing to getting that done right. In a medical malpractice case, I always like to say that the discovery is everything, that I make or break my case at discovery. I need admissions from the defendant nurses and the defendant doctors in order to succeed in my case. And I'm not going to get those admissions unless I'm properly prepared for the examination. That means that the time to look at the records and to prepare your summary and your chronology is right at the get-go, right at the start. The second the records come in, I will prepare, and later I'll demonstrate how I do this, but I will prepare a detailed chronology of all of the records, which page references and commentary. And I will update that from time to time. But after I prepare that detailed chronology, I then sit down with my client before I retain an expert, before I have somebody else look at the documents. And I will go over with the client my understanding of the issues. I will make sure that with my client, I have identified the areas where the client might be critical of the care that's been provided. And I will identify additional areas where I think there might be criticism of the care. I will research these things. I will look at medical literature, medical textbooks. I may even consult orally with some experts to ensure that I understand what the issues are in the case. And then I will formulate the questions for the experts from that. When I go to meet with my experts, I don't take volumes and volumes of records. I have my summaries, and I can carry them in one hand. It's a summary of all the events with all the relevant page numbers, and if I have to, I can access stuff on my computer, so I do that. And then when I go to examinations for discovery, I don't need any notes. If I follow my chronology, I'll know exactly what questions to ask and in what order to ask the questions. And then after discovery, I can enhance my chronology by adding what the party said about events that are identified, what the experts have said that are identified in the records. I can do all of those things and update that chronology so that by the time I get to trial, it's a complete chronology that has everything that I need to also allow my trial to run smoothly. But as the person meeting with the experts, and I always meet with my experts personally, as the person conducting the examination for discovery, and I'm not a good delegator when it comes to discovery because that's how I make or break my case, and the person who conducts the trial, I must know the records, and I must know them well. I think it's a very, very important preliminary step. The last thing I'll add about the records is that if I am going to invest in a medical malpractice case, I like to satisfy myself that it's worth the investment. And I can't satisfy myself it's worth the investment unless I've taken a hard look at the records and the issues and made some evaluation of the merits of the case. That assessment may change at the various stages of litigation, whether it's at discovery or pretrial, or after I get the defense responding expert reports. But at least at the beginning, I have some sense about whether or not I have some faith in the case, whether my client ought to have some faith in the case, and whether we're going to invest $500,000, $600,000, $1 million in a case. It's not unusual to in the bigger cases to invest $1 million in a case. So these are important preliminary steps that everybody has to take. So those are my comments, Janet.
Those are great comments, Richard, and I agree with you wholeheartedly. And I agree about examinations for discovery and how important they are. That's where we're getting our evidence to support our case. So I think that's it for this presentation. I hope you've all enjoyed it. There's contact information with respect to the phone number there. That's the office line. If you have any questions, certainly Richard or I are available, and we're happy to talk about any of these cases or clarify anything with anybody. So
thanks, Janet.
Thank you, Richard, and goodbye, everybody.
All right, here we are in Ottawa. It's Derek Nicholson here, and also Daniel Bartlett. Say hello.
Hello.
I'm with the Ottawa office, or head up the Ottawa office of Nicholson Gluckstein. Danielle does all the hard work, and we're here today to talk about demonstrative evidence and the law and experiences in terms of how it's developed up until the year 2020. Now, it goes without saying that demonstrative evidence certainly can shorten the length of the trial, but it also increases the retention of jurors or judges from about 15% with auditory memory to 65% according to the studies, using models, graphs, anything like that.
Now, there's really three types of evidence that you see at a trial. There's the oral evidence, which is sworn witness testimony, documentary evidence, so we're talking clinical notes and records, and demonstrative evidence, which is visual aids. Can be real or substantive evidence, and the jury uses that to draw inferences. So photographs, videos, that could be x-rays and MRIs. In a criminal case, that could be the actual murder weapon. Illustrative evidence, that's medical diagrams. So can use this to explain oral or documentary evidence, and it can make other evidence easier to understand. Juries are hearing very complex medical evidence that they've never heard before, and the illustrations would help explain it to them.
Now, I wanted to just talk about some practical points, and hopefully these are the takeaways, almost the conclusions that I hope you pull away from this particular conference. To begin with, it's very, very important when you're planning or approaching trial to make sure that you've got what you need to properly present the demonstrative evidence. There's actually one of the great cases to read when you're getting ready for a trial to see what not to do is the BC case of Luckett and Chahal. And in that particular case, they were dealing with artery studio photographs that would easily have gotten into evidence, but the lawyer who was presenting them, the plaintiff's lawyer, did a horrific job and didn't do any of the things he was supposed to do. He didn't give an expert report to verify that the illustrations that he was trying to use were accurate and fair. And so this is a little checklist of things that when you're developing your case and you're planning that you're going to eventually use demonstrative aids, that you need to think about and start collecting and sharing with your opposing counsel, so there's no big cry at the beginning of the trial that they've been overreached. The first is you absolutely need an appropriate expert to verify the veracity and fairness of the demonstrative evidence. And in that Luckett case, what had happened is that the fellow was planning to call an orthopedic doctor to testify about drawings of the neurosurgery that another doctor had done, a neurosurgeon had done, rather than calling the neurosurgeon. And in fact, there was no intention to call a neurosurgeon or file a report confirming that that was a fair likeness of what had actually transpired. The second thing to do is to make sure that you have clearly provided opposing counsel with all materials, all clinical notes and records, any studies, any articles which your experts rely on, any information whatsoever, so that they are able to cross-examine the expert who's going to testify about the veracity on the voir dire. Also, you want to be able to have the illustrator available and perhaps testify if necessary, if there's objections. So in the case of RV Studios, somebody like Stephen Mader might testify to verify the accuracy and fairness of it from a technical point of view. You might also want to ensure that there's no editorial or unnecessary opinions appearing on the illustrations or the CGI animation or whatever you're producing, because that may be seen to be biased and prejudicial and may get your illustration blocked. Make sure there's no inflammatory colors. For example, in that Luckett case, whenever it was a head that was going forward, and supposedly the demonstration, the animation showed it bumping, and whenever it bumped, there was a bright red flash, and the judge felt that that was unduly prejudicial and not worth the probative value of that particular illustration, so it wasn't allowed in. And the final thing, and perhaps the most important thing to start thinking of right from the beginning, is preparing Mohan materials so that you're ready to argue the admissibility of the matter, because generally speaking, you're going to want to refer to these illustrations in your opening. And if you're going to do that, you need to file the necessary materials and affidavits of the illustrator, of the expert, and so on, so that you can argue and present the judge with submissions that you should be allowed to bring it into evidence, and consequently you can refer to it in openings and in front of a jury. That increases their understanding from 15% of what they're hearing to 65% in relation to what they're looking at. So as we mentioned a moment ago, we are human, as humans, visual creatures, and visual displays improve recall.
Juries are usually lay people. The reality is we live in a very media saturated environment. Instagram, quick videos that are entertaining. We're pulling jurors from their everyday lives into a courtroom. They've seen a lot of court on TV, Law and Order, and they expect to be entertained. And demonstrative evidence can actually be very persuasive to them, and it'll wake them up and capture their attention.
Also, with your experts, if you have models or illustrations, studies have shown that it adds significantly to the credibility of your expert and the understanding of the jury.
And there's actually been a lot of studies just on how juries take this information, the demonstrative evidence. And the studies have shown that visual displays can improve recall when shown to mock jurors. People have stronger emotional responses to pictures. That's just the reality. It can affect their thoughts and feelings to see, for example, a really traumatizing car accident photo of a car crumpled up. So it can create a strong emotional response. And one study did find that it impacted the jury outcome and awarded higher damages in that case.
The other advantage to illustrations is oftentimes when I'm doing a trial or we're doing a trial, you leave up the demonstrative evidence on boards, and usually the other side doesn't think to object about to that, but then the jury's always meandering over and looking at them again, and so they continue to have an impact throughout the trial.
Yeah, and it can also bolster the credibility of an expert witness that's relying on the illustrations or the photographs. An expert witness was found to be more credible where their testimony was supplemented by animations. So that's something to consider as well.
So if we take a look at what has been used in the past, just to give you some idea, and I'm not reading with the list that's on the screen, but including the list, the items on the list, photographs have been obviously admitted millions of times, starting with Draper and Jacqueline in 1970. And that particular case set forth the three essential criteria of accuracy in representing facts, fairness, so that there's no obvious bias or intent to mislead, and verification by a person who actually knows what's going on in the photographs or can identify it as being true and accurate. Secondly, videotapes in R versus Nikolowski. The videotape was accepted, and the court commented that with proper video, there's no human frailty of memory failure and that sort of thing. Same with audio tapes in R and Pleach, which is a 1980 case. Taped conversations were seemed to be much like testimony, much like original evidence, and of course eradicated the memory problems I mentioned. Experiments can be done as well, as long as you set the proper foundation with the proper experts. Reenactments are much more risky, of course. There may be a discretion in the court not to allow reenactments, but in the appropriate case, it can be considered. There was a case R and Vieno, V-E-I-N-O-T, in 2011, and the judge was concerned about the gatekeeper role that he or she had, but allowed a reenactment to take place because it would assist the trier of fact. Illustrations we've already mentioned, that's the Luckett case, and Smith and Morelli is a case from 2011. And CGI, computer animation, has been allowed in McCutcheon and Chrysler, and modeling has been allowed. And there's probably an endless number of things depending on how creative you are, but those are some examples. This is Artery Studios illustration that was used in a trial. It was to demonstrate traumatic brain injury, diffuse axonal injury to somebody who was having cognitive issues and personality change, to try and demonstrate at least that there was some indication objectively of brain injury. This is a knee surgery demonstrating the screws that go into the knee. I think we've probably all seen these, but be very helpful with a jury who has no idea about anything to do with medicine. This is a case with a gentleman who developed ulcers, unfortunately, in his backside because he'd sat in his chair for so long. And there was a claim against a company who mismanufactured the chair he was in. And this ulcer, unfortunately, as can be seen in all of the different parts of this illustration, eventually led to him developing an internal infection and losing his colon, which was not a very pleasant scene for him. This is how they did the colonoscopy, where they reached in and pulled out the intestine and connected that to a bag, which I'm sure you've all seen them with. And unfortunately for this man, who is a paraplegic and already confined to a chair, added to his misery.
Very effective diagrams.
This is something that Richard Halpern has provided to me, and this is very helpful for medical malpractice cases to demonstrate the fetal heart issues that come along with the it's a graph of the problems they're having when the infant is starved for oxygen, becomes deprived of oxygen. This is another sample that Richard had from a case where he was explaining to the jury the sequence of the various instances in a compromised baby case. Demonstrative evidence is also improving, and this is a list that we sort of developed in conjunction with Stephen Nader from Artery Studios. They're doing using visuals that morph in exact alignments to allow for comparisons. For example, it was a case where somebody was demonstrating they had a difference in their gait and it was affecting their spine and ultimately would cause very catastrophic results down the road. They have 3D models, they can print them now. They also have interactive timelines to portray key timing factors. And also they have, excuse me, they have
yeah, visuals that morph to explain key procedures and parts For example, this is the heart. You can see that the picture changes here. It morphs very slowly.
So you can, that's when they insert the stent.
This is showing an impaired vision for a client. Kind of gives the jury, or the trier of fact rather, an idea of what that client experiences. 3D printing, these are physical models. They're tactile, so they would help people actually engage and get to maybe touch the diagram if you had the actual model, and there's also just the 3D photos. Models printed from imaging, photograph, and labels are added to act as guides for the viewer. Interactive fetal monitor strips to ease use, utility, and comprehension.
Mostly used in compromised baby cases, of course, and I think it's important to remember to lay the groundwork from an evidentiary point of view for all of these different types of demonstrative evidence.
And just touching on the relevant legal issues to actually admit demonstrative evidence, there's just some general principles. There's a criminal case, RV Kanagavism, probative value must outweigh the prejudicial impact of the evidence. The demonstrative evidence is not supposed to be used as a tool for advocacy. It's not supposed to paint a picture of the party's position. It is intended to facilitate the jurors' comprehension of the facts. It's supposed to explain things to them in a way that they can understand. And ideally, you want them to be able to take it into deliberation with them to associate that visual image and help them remember the facts that you want them to focus on. Demonstrative evidence, it has to be relevant, accurate, and fair, so no intention to mislead. If you're admitting a medical instrument that was used in a procedure, you should be tendering evidence that it is the one that was used in the procedure and it has not been altered, and the evidence hasn't been distorted in any way. You should verify it under oath to the extent that's available. Relevant, I'll go back to that. So that's just legally probative. So the evidence should be make one of the elements of the case likelier than it would be in the absence of that evidence. You want it to be more probative than prejudicial. If it's so prejudicial to the other side that it outweighs the probative value, it will be excluded.
And the other thing you don't want to forget too is that even though something to be admitted and to be relevant can be, not super important, but by the same token, the case law is very clear that if expert evidence and modeling and illustrations will consume too much time but have virtually no value, they will be excluded.
Exactly, and if it's prejudicial, it will cause, that will ideally, you don't want the jury to lose objectivity. One thing interesting to note is that a photograph is rarely excluded if it's too graphic. That's sometimes come up in the studies, but if evidence is just too gruesome, it will usually not be excluded based on that. Whitford and Swan is an Ontario General Division decision that discusses admissibility of demonstrative evidence in your opening statement. There is a 4-part test that you should meet, so you'll want to think about these things when you're trying to get it admitted. Will counsel using or proposing to use the aid undertake to prove it? So you have to show that you're going to prove it in the trial later on. Is it relevant to the case? Is it likely to assist the trier of fact in understanding the case? And lastly, is there anything unusually prejudicial about the demonstrative aid that it would require it to be excluded?
By the way, before we move on from that, I meant to mention in the beginning, we're all talking about, having a Mohan kind of battle over admissibility and whether it's prejudicial and all that. But most of the time, it's far better to approach counsel before the trial when you're working out on consent, what exhibits you can file. And of course, you can use in an opening statement a model or an illustration if you've got the parties to consent. And so you might always consider that to avoid the rest of it.
Timing is very important as well. You don't want to serve it to counsel 2 days before trial. So make sure you meet timing requirements according to the rules. Smith v. Morelli is a 2011 case. The plaintiff wanted to admit a number of demonstrative aids in their opening address, such as the motor vehicle accident report, photographs of damage to the vehicle, a diagram of the plaintiff's hip and femur, x-rays, photographs, some excerpts from the expert reports, and a 3D model. And the court found most of the aids were admissible, with some exceptions. They found that the plaintiff did intend to and would prove each item. The items were relevant to the case. They weren't misleading. They weren't exaggerated. There's no question the aids will assist the juries, the court said. But just to address the defense concerns, the judge would say in their opening statement that, you know, the demonstrative aids that you're about to see are only to assist you with what you're about to hear in the case and nothing more at that point. So he also found excerpts in one of the reports from the expert did have the potential to create prejudice. Derek discussed this case in quite a lot of detail. This was a BC case where the medical illustrations were inadmissible. The prejudicial value or the prejudicial effect outweighed the probative value.
I might just say one thing about that. It was only the red color. The rest of it was all plaintiff's counsel's failure to properly develop the evidence for the case. And they didn't preserve any of the materials until just a few days before the trial. So the evidence itself was good. It would have been admitted had it been properly presented, except for the red that I mentioned before.
Exactly, and it wasn't an unbiased illustration. It was to show the plaintiff's pain and maximize the damages, and the court just found it was too shocking. It was meant to shock the jury, and that's not supposed to be the intention of demonstrative evidence. Smith v. Delgadice is an unreported decision. This was a case that Roger Oatley was involved in. Admissibility of CGI, so computer graphic imaging, in a personal injury case. The plaintiff erred in not using a report from the animator who prepared the animation. It was an American animator, and apparently American courts, they don't require you to use a report from the illustrator or the animator to verify it. And they also didn't have a reconstruction engineer actually verify the accuracy of the animation. So that CGI was not admissible at the trial. Justice McKinnon provided some factors to actually guide counsel in admitting the CGI at trial. So answering these questions, is the evidence admissible, considering relevance, accuracy, whether the video has the capacity to and does mislead, can the facts be verified by the persons that are capable of doing so, is the video necessary to assist the jury in understanding evidence from example the expert, does the video contain editorial comment? If it does, you should have that person there to testify to the authenticity of the comment. If not, the court may find that the, for example, narration will not be admissible, but only the video would be. And will it shorten the trial? So it should summarize complex evidence and ideally make the trial shorter in that way. We also talked about this case, McCutcheon and Chrysler Canada. Again, this was a CGI evidence and it was found to be admissible. It was relevant to issues in the case. The CGI was showing the plaintiff's pre-accident and post-accident gait, so comparison videos of walking. The judge found the video was not inflammatory, it was not misleading or unfair to the defendant, and they had a qualified witness there to verify it.
Well, thank you very much. I hope you've gotten some help out of this. This area has become incredibly important because in the last several long trials I've done, like the last one, I think there was 6 Mohan motions, and 3 or 4 of them were to do with illustrations and modeling and that sort of stuff. And and there are many good articles, and we also have a bibliography that if you would like it, you can write to Danielle Bartlett, who did all the hard work on this presentation, and she can send it to you.
everyone, and welcome back from lunch to the Gluckstein Medical Negligence Conference. Thank you all for sticking around after lunch. I hope everyone had something to eat and has the energy to come back and pay attention to an afternoon of really great presentations. My name is Jan Marin, and I am a senior associate at Gluckstein. I focus almost entirely on medical negligence actions and professional negligence actions. Today, I'm going to speak about client management in these matters. It is a little bit different, and there are certainly some elements which are going to be common in any personal injury action, but there are elements that really need to be paid closer attention to and altered a little bit when you're dealing with a medical malpractice action. For the very experienced counsel in the room, I'm sure a lot of this is really going to be information that you already know, but for those who are just getting into medical negligence, have had just a few actions or are thinking about it, I hope to really give you a sense of the ways in which there needs to be differences in how you manage these clients and these matters, because it does matter. So the first thing I want to talk about is when we are first dealing with the client. And this is the first touch point. So the initial call with the client. This is a time to get a really detailed history. In other areas of personal injury, there may not be the same need to get the level of detail required as by these medical negligence matters. It's really important to understand not only the story that your client's telling about what happened, but also to understand their prior medical history and also damages. We can't forget that these cases are more expensive, more time consuming, and take a lot longer than other areas of personal injury. And for that matter, it may not be my favorite thing to tell a client that their matter doesn't meet the threshold for these cases, but it's really important to be successful in practicing this area of law, because these, again, are very expensive, time-consuming matters that if the case doesn't have substantial value, you will never, either for the client's sake or the lawyers, it won't be worth the time. So it's really important to understand that right from the very beginning, so that you don't spend a lot of time and a lot of energy, on matters that aren't going to go anywhere. The records are really important at this stage. If I can get records before I even meet with the client, that's ideal. And I would say 90% of the time, that is what happens. There may be cases where clients aren't able to obtain the records. There are very significant value cases that we're for sure going to investigate for the clients, even without knowing the really detailed particulars of the medical history. But 90% of the time, I get a copy of those key records, or at least what the client has on hand, before I even set up that initial meeting. I want to get my eyes on those records. It's important because not only is this very sophisticated information, but the story is not always the same from the healthcare team's perspective as it is from the client or the family member that's telling me about what happened. And that could be for a number of reasons. That could be because there's an element of the client's misunderstanding of what happened. There could be some inaccuracies in the records, but more often than not, there's more going on behind the scenes than our clients realize. And that's important, not to mention that regardless of whether there's an error in the records, these records are going to be what we have to live with. This is the hard evidence that's used in these cases to assess these matters. And the records, I can't undervalue the importance of the records and seeing them at a really early stage. It's also important, from my perspective, to get a sense of the medicine before you meet with the client. So if I'm dealing with an area that I haven't had much experience with before, I take a look at the literature. I have a membership on Up to Date, which is used primarily by healthcare providers and physicians to give a fairly high level, but also with links to literature, about what to do in a particular situation, what are the key signs and symptoms of particular diagnoses, and it gives me a really high level understanding of what we're looking at. What are the concerns? What are issues that could present themselves? If I have a client coming to see me that they're saying they were given a drug improperly and that there were drug interactions which had them to have an adverse consequence, I look up that drug. I see what the other drug interactions are and what is allowed, what is not allowed when you're on that medication, what's recommended, what the potential symptoms are that can come from taking that medication. I look at all of that ahead of time because I want to have a really good sense of where this is going. Often, if one of my clerks takes an initial intake, I will even look up that literature before even calling the client back, because I want to know what are the right questions to ask. What are the things that I need to know about right from the beginning? Because if that patient has a heart history, if that patient has some underlying condition, which means that they shouldn't have been on that medication, these are all things that I need to know really early on. So these initial touch points are really important and key times where you want to have a good sense of the case before you spend a lot of time on it. That's really important, and it will allow you to have a lot more success in these matters. I'm going to talk next a little bit about retainers and the importance of the particular retainer that we use in these matters, as well as the element of asking for a financial retainer. It's not something that most personal injury lawyers are used to doing. Most personal injury lawyers are happy to tell their clients, you won't have to pay a cent until you get an award in your favor. This is not going to cost you anything. And it's certainly something that clients want to hear. They want to know that. We're very proud of this fact. It's an access to justice issue. Anyone can have the best lawyer. But in these cases, we're dealing with a bit of a different animal altogether. We're dealing with, again, as I've mentioned before, really expensive cases that require a level of expertise, not just by the lawyer prosecuting these actions, but also in terms of the team. These matters can't proceed without an expert opinion. It's a base requirement. Now, of course, it's required by the lawsuit itself. You need to have this evidence in order to be successful. But more importantly, and something that I've seen other lawyers not necessarily do from day one, is to get that expert opinion before they start their case. So asking for this money is really important. It is something that's hard to get used to when you're used to saying to clients, this won't cost you a thing, and being proud of that fact. I certainly felt that way when I first started asking for it. But as I've spent more and more time on medical negligence matters, things that perhaps didn't go in the direction I thought, I've learned over time how important it is to ensure that there is some investment by the client into this initial phase. It's important for the lawsuit, but it also is your client investing in their own lawsuit. I'm very clear with them that they're not paying for me. All of my time and energy in the investigation of this matter isn't going to cost them anything if it doesn't go ahead, but that I require an expert opinion, and I do need them to contribute to that expert opinion. I certainly do think about means and what that client might be able to or not be able to afford. There are times when I can go to someone who may not be the expert I want to take to trial, but I can get an opinion from someone to give us at least an initial opinion that's oral from a review of the records that can cost a little bit less. So maybe in that particular matter, that client can only afford $2,500, and that's what we do. But it allows them then to take on some of the risk of this initial piece of the lawsuit. The other thing about our retainer is that we have a specific retainer that's a limited retainer that we use for our medical negligence cases. It is different from the traditional retainer that personal injury actions use. It's a limited retainer, which means that it's only for a particular piece of the case. In this case, investigation. It's very clear, and I'm very clear with my clients right from the very beginning, that this retainer that they're signing allows for us to investigate the matter And that is what it covers, such that if the investigation shows that the case does not have merit, then we won't be proceeding with their case. It allows us not to be in a conflict situation where the client truly wants to proceed with the matter. We're saying we are not prepared to do that. It makes for very clear communication from day one. And the other element of those retainers is that it allows for the financial retainer. There's a spot on our retainer to enter in the amount of the financial retainer, what it's going to be. It describes how it'll be used, and that if there's any remaining funds left, if the matter is not proceeded with, they'll be returned to the client. And all of that's really important to have documented. It's not a great place to be in where you just verbally say to the client, I'm going to need you to pay me $5,000. And then there's no discussion about where that money goes, how it'll be dealt with, what'll happen if the client decides to go a different direction, or if there's money left over, etc. So I think all of that's really important to think about doing in your practices, because again, this clear communication piece leaves clients feeling like they were treated fairly and honestly from day one. Explaining the elements of a medical negligence action can be difficult. These are complex issues, even for some lawyers to understand. So understandably, clients may have some difficulty understanding these pieces as well. At the first meeting, of course, we have a discussion, as I mentioned, about the difference of these actions from other personal injury actions. We talk about the CMPA, or the Canadian Medical Protective Association, how they operate differently from an insurance company. Risk management isn't their key concern. They're more concerned with reputations of physicians, and for that reason, no nuisance settlements are paid. These are not cases where we can say, well, there may have been negligence, there's a small chance, and they'll pay a small award. That's not happening. That's not the way these cases go. And I'm very clear with these clients from day one what will be required to advance their case. It has to be a merit-based case. It has to have an expert opinion. The expert has to be credible. No hired guns can be used and relied upon in these cases. It has to be an objective person. And I also tell my clients that having an objective expert is key, because then we know what arguments the other side's going to make. Are these credible, strong arguments, or are these arguments that we're going to be stronger on? These are important things to know right from the beginning. Clients do need to understand about standard of care and causation. That is so important because they're the key elements of medical negligence cases. So when I'm talking about standard of care to a client, I always tell them that this is essentially what the physician or other healthcare provider was required to do for whatever presenting condition they came with. What did they need to do? It's set by other medical providers with similar experience and training. It's based upon a medical provider facing a similar circumstance and how they would act in that same circumstance. And there's reasonableness here. There's no perfection standard when it comes to physicians or other healthcare providers' care. They don't have to be perfect. They have to be reasonable. And that's really important. And that language is really important right from the beginning. And I say that more than once. They're not required to be perfect. That's so important because often in these cases, clearly they're coming to us for a reason. There's a poor outcome. Clearly it's not the outcome the patient wanted. It's not the outcome likely that the healthcare team wanted. And so how do you explain this and that this happened and perhaps that the team still met the standard of care? These are humans and they do make mistakes, and some mistakes are negligence and some mistakes are an error in judgment. They are able to make judgment calls based upon what they know at the time. If they exercise reasonable care, then they will meet the standard of care. But if other medical professionals, by and large, would have made a different choice or offered different treatments, there may be a breach of the standard of care. They're under a duty only to treat what is within their expertise. If it's a condition they're not familiar with, or they're using medications or techniques that are outside their training, these could also lead to breaches in the standard of care. And I talk about those examples so that they can understand. Causation is the more difficult of the two. It's particularly more difficult in the face of evidence that the standard of care was breached. Whenever I have a case where there's some level of certainty around the standard of care, that it's clear that the physician didn't meet the standard, but causation test isn't met, that's a difficult situation to be in. It's difficult for the clients to understand and accept. And again, it goes back to these initial conversations and the after the expert opinion conversations about causation so that they can understand. I start by telling them that the vast majority of people that are going to their doctor, going to the hospital, are going for some underlying condition, and have them agree. You'd agree that your cancer wasn't caused by the doctor, right? You'd agree your stroke wasn't caused by the doctor, right? And even if you'd had perfect treatment, you may have had some consequence. Some people whose cancers are found early on still have a bad outcome. That can happen. Some strokes, even when treated right away, there can still be some residual symptoms. And that means the test between a potential mistake and the ultimate outcome, there's not going to be a line there between the two. Humans are complex. Many factors contribute to health and well-being. And when someone sustains an injury or an unexpected outcome, there can be more than one explanation for what caused the problem. One explanation could be a healthcare provider mistake. One could be other medical history. There could be underlying conditions. You need to figure out what is the cause, and that can be a really complicated question. And it's something certainly that needs to be investigated by our experts. Some of these cases, it's a very straight line, but more often than not, this is the very complicated element of the case that can be missed by some lawyers, that they go full steam ahead on their standard of care case, but don't evaluate the causation piece prior to advancing the lawsuit. And that's a mistake. You're going to spend a lot of time and a lot of energy and not know that part of the case. And if you want to work smart and not hard, it is absolutely important to evaluate causation as early as you can. Sometimes you don't have all the records, you need more information following discoveries to do that, but it's also really important to do and communicate all of those risks to the client so they understand. As I mentioned just a minute ago, communicating an unsupportive opinion, particularly on causation, after you've had a positive standard of care opinion, can be really difficult. And maybe one reason why you might choose to get a causation opinion before standard of care. It can be really hard to tell your client that while the standard of care was breached, we don't have a causation case. It's one of my least favorite conversations to have because it's so difficult. And it's something that I leave that door open right from the very beginning, that this is something that is not a for sure. This is something that needs to be established by expert opinion. It's certainly something that we need to figure out. And that way it's not a complete shock to them when they find out about an unsupportive causation opinion, because that's a really difficult situation. It's certainly something where, of course, we always offer clients that they should obtain independent opinions, legal opinions, that is, and there are cases as well if the client's willing to fund it. I have got a second medical opinion. It's an unusual case that I recommend that, because again, that's a significant expense in the face of already one unsupportive opinion. There's also the reality that if your first expert isn't supportive on causation, that there's certainly going to be arguments the other side's going to be able to make on that front. And those are all issues that I address with the client so that they fully understand before we even consider taking those steps. I think it's pretty clear by my comments so far that these cases require significant time and resource management. And these elements from that very beginning point, when I said at the beginning that first meeting, you need to tell the client why you have a threshold for these cases, why the CMPA is different. At all of those times, you'll be communicating to them the differences that these cases have and why they're a little bit different, because we've all had clients who tell us, well, I know somebody who was involved in an auto case and this is what happened and this is how long it took. None of that is relevant in comparison to a medical negligence case. It's simply not relevant. I'm very clear about that right from the very beginning. I explain what my role is going to be. I'm going to review the records. I'm going to review the literature. I'm going to become an expert in this area. If I'm going to be successful in a medical negligence action at trial, I need to know my case. I cannot just rely upon the expert opinions. I need to understand it as well. I also explain the significant disbursements required. And this is part of that financial retainer discussion. These cases are not for the faint of heart when it comes to disbursements. It is unusual for these cases to require less than $50,000. Frankly, $100,000 and above is more of the typical range of disbursements in these cases. And so when you consider that in the scope of the cost, the investment by the client initially is very small, but it also explains to the client just how committed you are to their case, just how much financial investment the law firm will have in the case. And that's important. I also talk about the lengths we go to in these cases, including meeting with experts. We have sit-down meetings. Of course, the pandemic has changed that, and now there's Zoom calls, but we actually sit down with the records, sit down with the experts, with the records, with their report. We review everything in detail, and that's really important. And again, it goes back to knowing your file, knowing your case. You need to know it as well as they do. And often I know my records far better than my expert does. And I have questions for them. Did you look at this vital on this date? Well, what about this? There was a time period here that there was a gap in time of assessing the vitals. If I don't know that in detail chronology, I can't have a meaningful discussion with my expert. And this is important for client communication because they need to understand just how much effort as the lawyer you plan to put into their case. In terms of the client, again, communicating with the client, what's going to be needed from them. Updates, that's important. What's going on? What's changing? You know, if their condition improves materially, I want to know that. If their condition deteriorates, I need to know that. We need to have these updates. This is common in, I would say, most personal injury actions. So it's something we're all used to doing, getting those updates, ensuring clients know that they need to communicate with us regularly, respond to our office, things of that nature. And similarly, participation in discoveries and mediation, all of that is typical. What's more likely in these cases is the length of time required, as well as the possibility of trial. As I'm sure most people here know, more of these matters go to trial. That's, again, another important client communication piece, telling them that that possibility is greater than other matters, and it is certainly something they need to know from day one. They also need to be available for assessments when it comes time. This is something that we're going to need from the client and need their participation in. I touched upon this earlier, but ending the retainer in these cases is something that happens more frequently than in other cases. And what I mean by more frequently is ending the retainer without settlement, without a judgment in their favor. The CMPA stats are clear that far more of these cases end without a settlement, end in a dismissal, end up being withdrawn or discontinued than other cases. And this is something that needs to be known by the clients from day one. These conversations are very difficult. Most people, especially in the cases we're talking about that have significant damages, these people have suffered significantly. They've had very poor outcomes, and they have hopes and dreams that perhaps are dependent upon the results of a lawsuit. Maybe they can't work, maybe their family member or their child is going to have significant care needs. So it's a very difficult discussion to have. It's part of the reason why doing it earlier is better than later. You don't want hopes to get to the point where the examinations are occurring, you've got some positive expert opinions, they think everything is going along, and all of a sudden there's some new piece of information you didn't realize or didn't fully investigate early on. So early investigations make this so much easier. The costs are less. certainly then there's a discussion about the risks of proceeding in the face of there being some unsupportive evidence and providing options for the client. So I often, and there's certainly some disagreement about the value of doing this, but I always tell the client they have the option to make complaints if they want to, whether it's to the College of Physicians, the College of Nurses, the Ombudsman for the hospitals. While we know that there's not going to be a significant outcome in most of those matters, there might be a recommendation for education. There might be an undertaking given by the doc to take certain steps in their practice. I think having some independent investigation is still valuable to people, particularly in the face of being told that their lawsuit's not proceeding. And it's certainly something I tell to every person that I say, your case isn't one that we're willing to take on. I always let them know about their rights to do this. Again, I think it's an important service that we offer, simply to give a little bit of information to these clients, even on cases we're not taking on. We're leaving them with more information than they had before they came to us and giving them a little bit of direction. And that's all really important and good service for the client. What about birth injury cases? So we've had some presentations already today about birth injury cases. It's an area that Gluckstein prides itself on being an expert, have expertise on. Richard has had a number of talks already today about this. And there are some unique issues in these cases. So first and foremost, what is their motivation in coming to you? What are the family motivations? Often there's an element of what happened to my baby? This is a service that we offer these families because whether or not there has been negligence or there's negligence and causation is one thing, but most often parents don't understand what happened in the birth. It all happened very quickly, or in some cases over a long period of time, but it's a bit of a blur. They don't know behind the scenes. Some of them don't even know that their baby had an interpartum stroke. Some of them don't know that their baby was asphyxiated at all. They don't have that information. It wasn't communicated to them in a way that let them understand what it is that was going on. So that's an important thing that we always talk to about them, that we're going to be able to hopefully figure out what happened with your baby and at least give you more information than you had before you came to us. Then there's a discussion, of course, about what the family's needs are. They're usually significant in these cases. And the causation piece in these cases, it can be quite significant in these matters. We need lots of different types of opinions to establish causation. Neuroradiological opinion to establish what type of brain injury, what are we looking at. This is really important, an initial first step that often is not done, but it's really important to figure out whether or not we're going to be able to establish causation in these cases. Reporting on these details to the clients is also important on a number of levels. It demonstrates expertise. I recently had a matter that it's looking as though there was an interpartum stroke. In this particular matter, there's also significant interpartum risk factors in this baby. There looks like there were many breaches of the standard of care, but there's also a stroke, which leads to a situation that, as the literature stands right now, it's not causation that we're able to establish, because right now the generally agreed upon state of the science is that strokes are not linked to interpartum risk factors. But there's also some newer research which indicates that it might be. So in this case in particular, and we see interpartum strokes fairly often, and it is important to note to these families that right now, as the science stands, causation can't be established, and to explain to them, to talk about the medicine, to talk about the literature, to talk about why it can't be established, but to also explain that there is some conflicting literature out there. That's important, A, again, to show our expertise, B, to leave the door open so that if there's a change in the medicine, which can and does happen, that this might be a case that in the future might be an option. It's not right now. In lots of cases, you know, unfortunately, the state of the science isn't going to be helpful. In baby cases, it can be. The limitation dates are far longer for these kids. And it is something important to tell them that down the road, they may want to reconsider based upon the state of the medicine. If they have all this information in our letter, it's certainly something they're going to be able to look into, ask their health team about, look up for themselves, getting back in touch with us to figure out whether or not anything has changed. It's also another good example of why it's so important to investigate these matters before starting your statement of claim. You don't want to be in a situation where a claim is started, the matter's withdrawn, and then it can't be brought back. And it again emphasizes the importance of knowing what you're doing in these cases, being able to hold yourself out to these clients as an expert who knows what they're talking about. And if you don't and you want to learn, then it's important to get the experts involved that do know what they're doing. You can work alongside them. That's certainly something that our firm does. Richard's done a lot of co-counseling in these matters to make sure counsel, when they're dealing with cases that have a particularly high level of expertise required, that everyone is best served that way. So thank you so much for listening to me talk about client issues, which again, I'm sure some of you, none of this was new for, but I'm hopeful that those that are not so experienced with medical negligence can apply some of this to their practice. I'm happy to answer any questions that anyone has. Please reach out, send me an email. We can have a chat about it. Thank you very much.
Hi, Richard Halpern back. I'm going to talk about getting to know your case. We have already spent some time talking about the records, and I'll try not to be repetitive in this presentation. What I'm going to try to do is give you some examples of how I prepare a chronology and analysis of the case that helps me with my interaction with my client, with my experts, and in conducting examinations for discovery. So in order to prepare your case, obviously you need all of the data that you can get from your client. I like to ask my clients, where is your criticism of the medical care? And sometimes they don't know, or sometimes they've got it wrong, or sometimes they miss it. In some of the more complicated cases, there are a number of errors, one that follows another, or sometimes one that leads to another. And I think that it's important when you're doing an analysis of your case and the facts of your case to look at the broad picture and try to trace back the originating error as early as possible in the chronology. And the reason for this is that it makes causation much more easier. If there's a sequence of events that led to an adverse outcome, obviously the earlier the negligence occurs, the more likely it is that the negligence will be causative of the harm. Most of these clients, or many of these clients in any event, I would say, except for birth trauma cases, many of them come to you and to hospital and to treatment with a pre-existing condition. They have some medical condition that in and of itself may lead to a gloomy prognosis or some sort of adverse prognosis. It may be that that prognosis is made worse by the negligence as opposed to the patient having some prospect of cure. That's, in many of our malpractice cases, that's not the case. So what we look at is we compare what I call the trajectory of illness that would have occurred from the underlying condition that brought the patient to treatment in the first place. And we compare that trajectory with the trajectory of illness with the malpractice. I'm not going to get into causation, but you ask the counterfactual, what if the negligence had not occurred? What would the trajectory of illness have been for this particular patient? I've said earlier that I think that review of the records is not an obligation that can be delegated to nurses or to juniors or to anybody else. I think you have to know the facts of your case in order to conduct meaningful discoveries, to do a good job with your experts. And also, I think, to instill trust in your client that they've retained the right person to pursue their medical case. It's very important. I always review the records, and the clerks review the records too. We compare our notes, but I know that I have to know the records in order to get the admissions that I need at discovery to succeed in the case. And that means a chronology. We talked earlier about the fact that records can be thousands of pages long, and they're never in chronological order. And you may find them in different charts and different clinical notes and records in different files. And then there's so much repetition that it can drive you nuts, but there's lots of repetition in these cases, and you want to distill the tens of thousands of pages or the thousands of pages to as few relevant pages as possible, but of course you can't miss anything, and then you better be able to put your finger on it. Once you've distilled things down to its essentials, you can then come up with a theory of your case, both on standard of care and causation, and then you can develop the questions that you need to pose to your experts, as well as consider what experts you need to prove your case. I'm going to pause there for a minute. Some of the recent decisions out of this, particularly the Ontario Court of Appeal, suggest that perhaps those of us on the plaintiff side of these cases have not spent enough attention on causation. We haven't called the evidence on causation. We haven't considered the burden of proof on causation. Incidentally, and quite parenthetically, my view is there's only one single test for causation. That's the but-for test, and there is no such thing as material contribution, but that's a subject for another day. So then I do the research in the medicine. I have quite an elaborate library of medical literature that is expanding every month. In every case I do, I gather up all of the relevant literature I can find, and I read it after I read the records to make sure I've identified the issues, and I certainly read the literature before I consult with my expert. If my expert makes reference to literature, I do not allow my expert to deliver a report until I've read that literature. So I'm going to give you an example of what I do in a couple of different cases. The first one that I have is a birth injury case. And I know that maybe there's been a little too much emphasis by me, at least, on birth injury cases. It just happens to be what I spend about 75% of my time doing. But they're good to illustrate these concepts, but they apply to every case. And I'll give you an example other than a birth injury case. So this baby was, I say, asphyxiated during labor. The baby has cerebral palsy with a profound disability. And I think there are two chronologies that are absolutely essential to understanding and preparing the case. The first is a spreadsheet that contains all the antenatal data, interpartum data, and neonatal data, as well as an annotated copy of the fetal heart tracing. And I'm going to show you both and talk a little bit about what I do with each. So this was a rather long labor, and this is an Excel spreadsheet that I prepared from the records. I only have an hour and 10 minutes here. This labor went on for about 24 hours, so obviously it's considerably longer than what I'm showing here. But I just want to highlight what I've done here, and I think the color coding is important because you'll see that under the column date and time, that's just the times that are recorded in the chart. And then the green portion is the fetal heart rate. So these are all the features of the fetal heart rate. And I just wanted to tell you that these are things that I've extracted from the records. It's not my view, it's what the nurse has to say in the record. So, for example, the plus sign for accelerations means that the nurse found that there were fetal heart rate accelerations. This here, called class, the nurses are supposed to classify the tracing on whether it's normal to them, whether it's abnormal, or whether it's something called atypical. And you can see all the way down that the nurses never once recorded their classification of the tracing. And that's important because this dash in the column is a reminder to me that when I'm examining the nurse at discovery, I'm to ask her, or the doctor, I am to ask her what her classification was and why she didn't record it, and what's the basis for her classification. So all of the important features of the fetal heart rate are here, and they're color-coded so they're easily accessible. If I need to know where to find the data, then I simply go to the page number, and I've recorded it here in the chart. So I know under page 66, I'm going to find this information. It's very important to have that reference so that I do not disrupt the flow of my questioning at discovery. I do not want to take time to fumble through documents and interrupt any momentum I have in examining these witnesses. I also don't want to give them too much time to reconsider their answers, because they often do that. In the orange here, I have all of the features, not all of the features, I have most of the features. There's one feature of uterine activity I haven't included here, which is the resting tone. But I've got the frequency of contractions, so every 2 to 3 minutes, the duration of contractions, 60 seconds, and the intensity of contractions. And you'll note in this column that the nurse has failed to record the intensity of the contractions, and that's a breach of the standard of care. She's required to do that every 15 minutes at this point, and she hasn't done it. So again, it's a reminder the blank is as significant as is the positive findings. And you'll see that the blanks here for frequency and duration, the nurse has also been remiss in her duty to properly document. And this is very, very important in a case of this nature. Why? Because this mother's labor is being augmented with a drug called oxytocin. And oxytocin is a drug that enhances or increases uterine activity. It increases both the intensity of uterine contractions and the duration of uterine contractions. And you'll see that here at 9 o'clock, I have put in bold that oxytocin has been increased, and it's been increased to 20 milliunits per minute. Now, in most hospital protocols, 20 milliunits per minute actually is the maximum dose of oxytocin. So we're well into this labor. This mother is now getting the maximum dose of oxytocin, and putting it in bold is a reminder to me to ask the nurse, what was the clinical indication for increasing oxytocin at 9 o'clock in the morning? What did you think justified the increase, and why? And I will prove that it wasn't justified. I'm going to prove that she didn't have the data that she needed to do that. And I suspect I'm going to be embarrassing her. And you'll see under the comment section that I write, this is the only thing that isn't from the records. This is my comment, my personal comment. Again, intended not just to tell me what to do when I examine the nurse for discovery, but it also tells me what to talk to my expert about. So the nurse increased the oxytocin. I say that increase was not indicated. The tracing is atypical, not normal, and the uterine activity is not being recorded by the nurse. So it was not appropriate, in my view, for the nurse to increase oxytocin at this time, and that is going to go a long way to proving my case if I can get the nurse to agree with it. And I can tell you in the past that eventually they do agree. And it will be an important admission at discovery. So you'll see that in the comment area, I have my view of what's happening with the tracing, and you'll see that it's not consistent with the nurse's view. So while the nurse records, I say there are variable decelerations, and you'll see here the nurse records the presence of decelerations, but she doesn't say what kind they are. I say there's hyperstimulation, which means the contractions are occurring too often, and the nurse fails to say anything about what's happening with the uterine contractions. So again, this is something where I will embarrass the nurse. And where do I see these things on the tracing? I see it here on panel 43. So I have everything, and page 66. I have everything I need, every reference that I need to support my assertion that the uterus is contracting too much, and that there are decelerations that are called variable decelerations, which we associate with compression of the umbilical cord. So I think that's very important. And then you'll see that down here, I say this is an abnormal tracing. You'll see here that the nurse never called it abnormal tracing. She found that there were accelerations, which there probably weren't. She found that there are decelerations, which indeed there are, but she doesn't describe them. And again, importantly, she describes the fetal heart rate as being 165 beats per minute, and it has been now for 10 minutes. And 165 beats per minute is not normal. So fetal heart rate that's over 160 beats per minute is called a tachycardia. It's not normal. And I know that I'm going to have to put that to the nurse when I examine her, and I will embarrass her on it. So this is a small excerpt from a rather long chronology done on Excel, color-coded, with absolutely everything I need to conduct my examination for discovery. In fact, I only need this and the tracing and not another scrap of paper in order to do my examination for discovery. And it's all very accessible here. And I'm going to show you how I use the tracing to help me with this approach. Now, in the same case, I've done a separate spreadsheet that deals with neonatal care. So you may do a spreadsheet like this in a surgical case. You may do a spreadsheet like this in an infection case. You may do a spreadsheet like this in a late diagnosis cancer case. It applies in every case. The important thing is that this is a chronology that is taken, and you're going to see the page numbers, and this is why I wanted to show you this. So here are the page numbers. And you'll see the importance of doing a chronology because, of course, the references are not chronological. So there's page 212, there's page 860, there's page 153, there's page 3. It is not chronological in the records. Here I have it chronological. In virtually every one of these cases, it's critically important to have a chronological understanding of what happened. You may find the lab results over here, you may find the imaging over there, and you'll find the progress notes somewhere else. And it looks like when they sent the records to you, they first took all the pages of the chart, they threw them down a flight of stairs, they randomly assembled them, and they sent them back to you. So this is why this is so important. It's important to know the lab results in the context of the progress notes. These are critically important things to know. Not for standard of care, because you won't be examining your standard of care expert on this, but when you go to see your causation expert, you must know the chronology of events for your causation expert. And I will record all kinds of neonatal data. This is neonatal data, as it turns out. All the important things that occur in the newborn period that are going to help me prove that the baby was hurt during labor. So here, the baby is, and by the way, I also record the age of the baby here, 5 hours and 27 minutes of age. I usually do it all the way down. But here, even after 9, 10 hours of age, this baby still has a base excess of minus 12.1, which tells us that this baby has not yet recovered, even at 9 hours of age, from something that happened during labor and delivery. It must have been a severe impaired oxygenation or hypoxia ischemia of this baby during labor that could allow it to persist this long after the baby was born. In fact, I also recorded, I talked about another talk about multi-organ involvement. This is creatinine that's elevated that shows that this baby had kidney dysfunction at 5 hours of age. This baby was acidotic, lactate. The baby was acidotic at 5 hours of age. The creatinine remained elevated. This baby's glucose was a little over-adjusted, but a lactate remained high again. So all of these things, here I mentioned my comment, kidney dysfunction. Here, the baby got phenobarbital. I say that's for seizures. So this is an anti-convulsant medication, and typically babies who are injured during labor, one of the classic findings of the newborn is that the baby will seize in the first 24 hours of life. So this is, again, a small excerpt from a long, much longer spreadsheet that I will use when I meet with my neonatologist to explore causation and make sure that none of this data has been missed. Very, very, very important. So that's a very handy spreadsheet that I have. I told you that the second thing I do in a baby case when I'm examining standard of care defendants, doctors, nurses, or midwives, usually nurses and doctors, is that I will have the tracing with me as a chronology. And I just wanted to illustrate what I do with the tracing. So I have this tracing, this is one page, it's only 8.5 minutes of a 24-hour labor. So I've just taken out 8.5 minutes to show you what's happening and how I annotate these things to make everything go smooth. My meeting with my experts, my examination for discovery, my pretrial, my mediation brief, the whole thing, everything will go smooth because I prepared these things at the start of the case before I issue a statement of claim. So here's a clean copy of the fetal heart tracing, one page from the fetal heart tracing, 8 minutes or so. And here's what it looks like after I've annotated. So that's the same tracing, just been annotated by me. And the way what I've done here, this is so this is just before the baby's born. And I want to start by showing you that how important it is not to flip back and forth between records. So I've circled this legend, which is labor progress. And I've taken all the data from 2:20 in the morning until 10:48, the time of delivery. And I've summarized every internal examination that this lady has had and the findings. It's going to be very important, I know, in my examination. And I put this stamp on virtually every page of the tracing. And the reason I do it is because I want to be able to easily access information about the progress of labor at any time during my examination without having to recall what the findings were or the page number where I'm going to find it. So here I have the stamp and I put it on every page. And you'll see that I can find this data on pages 65, 66, 70, and 175 of the chart. Now, 175 is not in chronological order, so it's so helpful to have this. So I'm not trying to recall. Now, where was that last entry? Was it page 160, 170, 175? I can find it. It's very, very accessible. The other thing I do is I prepare another stamp. And this is a stamp that I put on every page of the tracing. And it's data from the second stage partogram. The partogram is just a graphic record where the nurse records all of this data, or she should record all of this data every time. So the page is 66, the time is 10:05. The nurse records a fetal heart rate of 165, variability is down, there are accelerations, decelerations, so on and so forth. I always know exactly what the nurse has done, and then I can compare this to what I see. And what I see and what the nurse recorded are not the same. The tracing tells the truth, the partogram does not. And I can't tell you how many times I have embarrassed a nurse by showing a discrepancy between what she recorded in the chart and what we see on the tracing. The tracing is the actual fetal heart rate. The nurse records accelerations, but she fails decelerations. Here's a deceleration. And the nurse records the fact that there are decelerations, but she fails to record the kind of deceleration that this is. And this is a very significant deceleration. It's called a late deceleration. From, by the way, a fetal tachycardia, here's the fetal heart rate of about 180 beats per minute. The nurse records 165. The nurse will be embarrassed when I examine her on this. Likewise, every progress note, I record the page, where it is and what it says about what happened at 10:08. So here's the time, 10:08. It corresponds with 10:08 on the chart. So this is a chronology where I have imported the data from the chart into this partogram so that everything is here, everything I need to know. And then I have notes here. I say, no. I have notes to remind me that when I examine whoever made this progress note, and I think it was the doctor said, fetal heart rate, normal. Not so. This is what we see here is a tachycardia, which is not normal, with decelerations and something called overshoot. This is a profoundly abnormal tracing, I will have no difficulty getting an admission at discovery that will embarrass the doctor and the nurses, that their notes are completely contradicted by the real chronology, which is this tracing. No fetal heart rate concerns, a completely absurd statement. Again, I will get admissions at discovery that will embarrass the nurses and the doctors with respect to this. So this is, and then I have they tried a vacuum delivery a number of times here, too many times, and I need to know exactly when they applied the vacuum and exactly when they pulled on the vacuum and exactly when it popped off. So these are all things that I need to know. The 2 minutes between the application of the vacuum and the vacuum popping off. And again, these are things that are going to have at my fingertips, and I never have to refer to another document. Let me give you another example of what I do. So it's a pediatric case. This is failure to monitor a baby who had a virus. So this is a young child, I think around 2 years old, who had a virus. And the baby, because they didn't properly monitor the fluid balance, the baby had excess fluids and developed a condition called hyponatremia, which is low sodium. Low sodium causes swelling of the brain, and this baby suffered brain damage. So the only reason I'm showing you this one is to show you that this is something where I have a chronology of the events that occur in labor, not in labor, during the care of this baby, and all of the relevant things that the nurse records at a particular time, I've extracted from the chart. And I have the page number here, and you'll see that I have page 16 of 27 and page 25 of 35. These are two different records. So when I record the page number, I know which record to go to, either the 27 page one or the 35 page record. I got the vital signs, and then I have my commentary like I do on other analyses. But now I've enhanced this chronology to add discovery evidence here. So this is what Jay said at examination for discovery, page 89. I've added what the experts have to say at this particular point in time on the plaintiff side. I've added what the experts have to say on the defense side about what happened at this particular point in time. So this is just an excerpt, but showing you that as I go along, I update these chronologies so that when I'm standing in a courtroom at trial and cross-examining anybody, examining, or I have this single chronology in front of me, if I have to find an excerpt from discovery that contradicts the witness, I have it easily accessible to me. If I have to know what the defense expert said at a particular page in his or her report, again, that's easily found by me at trial. And so when I add the stuff about discovery and about the defense experts and the plaintiff's expert, I already have the chronology that was done earlier. I don't have to redo it. I merely add to it. And therefore, all of the work that was done at the beginning, I benefit from at the end. So these are small excerpts of chronologies, Excel chronologies that I prepare at the start of a case after my one and only thorough review of the records. And I never have to review those same records again. I can access them. I can look at them because I always have the page number. But I've extracted everything that's relevant. So I hope that helps some of you to organize your thoughts in medical malpractice cases. I hope it helps you to deal with your clients, to deal with experts, and to do effective examinations for discovery. Thanks for coming.
Breeden, and I'm here to speak about getting the most out of experts in medical malpractice cases. And we're going to talk about some practical considerations, both for selecting and instructing experts. Before we start, I want to talk about why this is so important in medical cases more than almost any other case. And the reason is that there is a long line of authorities that establish that in almost every medical negligence case, it is impossible for the plaintiff to succeed without expert evidence as to both the standard of care and causation. There is the odd case, where they've amputated the wrong leg or left an instrument in the patient where it may not be necessary to have an expert. But in almost all of the cases, it'll be necessary to have somebody who is qualified and is able to persuade the court ultimately. And so that makes the selection, the retaining, and the instructing of experts particularly important in these cases. So the first question is, when should you retain the expert? And the best advice that we have is that you should do that as soon as possible. In an ideal scenario, you want to retain your experts both with respect to standard of care and causation, if you think that there's going to be any causation issues, before you issue the statement of claim. And the reason for that is because you want them to identify any potential areas of negligence or any potential defendants that you should be pursuing so that you can include that in the statement of claim. Sometimes, of course, that's not possible because the case comes to you having already been issued, or there isn't enough time to retain and get an expert opinion because of a limitation period issue. But certainly that would be the best practice, even where the client comes in at the 11th hour and you have to issue a claim to preserve the limitation period. My own practice is to hold off on serving that claim until I have obtained an expert opinion, and I think that makes good sense. You certainly also want to get your preliminary experts lined up before you retain any damages experts or you incur any significant disbursements in the case. And the reason for that, of course, is that if it turns out that the case isn't viable, you don't want to sink an enormous amount of cost into working it up. All right. The next question then is, who should you retain? And there are a number of considerations that are applicable for all experts. The first and the most important thing is that you should not retain what I've described as plaintiff hacks. So that means people who only show up on the side of the plaintiffs, who are going to tell you what you want to hear, but don't have any credibility either with the defendants or likely with the court. It doesn't do you any good in advancing your case to have an expert who ultimately is not going to be reliable. It's much better to retain somebody who will give you the honest goods right from the start, so you know whether you have a viable case or not. Good practice is to try to retain people who show up on the side of the defense in these cases, who the defendants retain, because, A, you can have some satisfaction that they're probably going to be objective, and B, they will have more credibility with the defendants if you're actually hoping to settle the case. Always research the expert before you retain them, and even if it's an expert you've used before, it's worth doing this. Go through, do a quick law search, a Westlaw search, see whether they have testified before and whether they have been the subject of any adverse comment. If the answer to that is yes, you probably don't want to use them. It's worth also looking at the college website and finding out whether they have any issues with the college, because again, that may limit their ability to show up for you. In terms of the specific experts, then it becomes a little bit different depending on whether you're looking at standard of care or causation. The standard of care experts should have the same qualifications as your proposed defendant. So if you have a community-based family physician, it is ideal to get a community-based family physician to be your expert. The same with specialties, the same with subspecialties, the same with really any sort of defendant. And the reason for that is that you want to be able, you want to avoid the potential criticism that your expert is coming at the case from sort of an ivory tower perspective, and isn't in a position to really talk about what the standard of care is for people out in the community who are likely going to be your defendants. For that reason, you want to avoid, if possible, going out of the jurisdiction, certainly going to the United States and finding standard of care experts. You really want to get people who have the closest possible qualifications as the defendant. Now, sometimes that's not going to be possible for a variety of reasons. You can always go and get a more academic expert, but you have to be prepared that you're going to be met with the challenge that they're not really in a position to talk about the defendant's practice. For causation experts, that same criticism doesn't apply. And so generally speaking, you want to get the best possible expert that you can find who can speak to the causation issues in your case, particularly if this is a case in which causation is likely to be a real live issue. Now, obviously, some cases that's going to be less significant than others. And what the ideal scenario from my perspective is if you have a case where the causation expert can also opine on standard of care. So, it's a surgical case and you're getting a surgeon to comment on the causation, but they're also qualified to speak to the standard of care. Then what you can do is get, a community-based or similar standard of care expert, number one, but also go for a very academic and specialized expert to speak on causation, but also have them speak on standard of care issues, because you've covered off both bases, and generally speaking, the more academic experts tend to write more persuasive reports because they're writing more often and can make better witnesses, although that's not necessarily the case. Once you have picked the expert, you now need to instruct them. And so it's really important that you include all of the relevant material that is available at the time that you instruct the expert. So of course, that's going to include court documents like pleadings, transcripts from examinations for discovery, relevant productions. It's going to include medical records. If there is a case in which you're asking the expert to comment on imaging, it's really important that you give them the original imaging on a disc or older cases in the actual films, as opposed to just the reports. And if there are expert opinions that have been delivered by the defense, you're going to want the expert to see those in advance. Organizing the medical records is very important because you can save the expert a lot of time and therefore you a lot of money in reading through and trying to sort out what the materials are. It is acceptable to provide the expert with a chronology or other type of assistance in navigating the records, particularly in very, very large cases. But be aware that anything that you provide the expert is going to be produced. And so it has to be completely neutral and completely accurate if you're going to do that. If you can avoid that, that often is the best. I always include in my instructing letters the requirements of Form 53 or the Rule 53 that sets out the expert's obligation to the courts. It's good to put that in writing to the expert, even though most experts in these cases understand that. And then in terms of your instructions, it is helpful to ask very specific questions. So ask the expert specifically what it is that you want them to answer and be as detailed as you can. If there is a case in which you have some assumptions that you want to provide the expert with, make sure those are set out clearly in writing and that you instruct the expert to assume those to be true. So in a case, for example, where your plaintiff is telling you a different story of what happened at a visit with a doctor than what the doctor has charted in the records, and you think you are going to need to rely on your client's account in order to make out your case, you're going to want to spell that out in some detail for the expert and ask them to assume it to be true. They will, in my experience, often resist that kind of instruction because they like to rely specifically on the records, and so you can give them some comfort by letting them know that you are instructing them to assume it and to premise their opinion on the basis of those assumptions. Reports then are really the key in dealing with these experts. And the first question is, when do you get a report? Now, my practice is to, whenever possible, get a draft of the expert's opinion early. As I mentioned earlier, I tend to retain experts right at the outset of the case before I've issued a claim. I get a preliminary opinion from them as to whether the claim has merit or doesn't have merit, and I like to have the expert prepare a draft report at that time. And the reason, there are a couple of reasons for that. So number one is the expert has already reviewed all of the materials and it's in their mind, and so they might as well get the draft down now rather than having to reinvent the wheel in a year or 2 years after discoveries. Secondly, I like to have the expert put their opinion down on paper because it commits them to what it is that they think about the case and minimizes the risk that after discovery or after they become a little bit busier that they change their mind and become less supportive. Three, it helps me in terms of both preparing for the examinations for discoveries and drafting the statement of claim. I don't have the opinion finalized because I don't produce that as part of an affidavit of documents. If the opinion is finalized, then it is producible. Drafts, generally speaking, are not. And in medical cases in particular, there is a somewhat of a convention that everybody gets their draft reports and nobody produces them before discoveries. After the discoveries are completed, you need to get the transcripts of the defendants and send those to the expert to review, and then have the expert finalize the report at that time. My own practice is I finalize the reports as quickly as I can, and I serve them as soon as possible, as opposed to waiting until shortly before the pretrial, mostly because I want to avoid any delays in getting the action on to trial, because if these cases are going to settle, generally speaking, they will settle on the courthouse steps. It is important that you ensure that the report is useful. And by that, I mean a number of things. So number one, the report has to be accurate. And this is really a responsibility for counsel. You need to go through the report and the medical records and ensure that the expert has accurately recorded the history and that the expert has recorded all of the material history. You know, obviously, to some extent, you're relying on the expert to figure out what is material to their own opinion, but you know, you should be prepared to raise with the expert any issues that they have not addressed, at least so you understand why it may not be material if that wasn't obvious to you at the outset. You should not assume that the expert is going to be completely accurate. Of course, some are very, very good, but others are a little quicker in preparing their opinions and may miss some of the details. And so you really have to ensure that it is accurate, because it will undermine the expert's credibility and the force of their opinion if there are a bunch of errors. Secondly, the report has to be understandable. So judges will receive copies of these reports almost invariably. And whether or not they be marked as an exhibit, I am quite certain most judges will read the reports. The report should stand on its own as a way of explaining what the expert's opinion is in a format that lay people can understand. Diagrams are very useful and are helpful if they are contained in the report. The report has to be consistent, and that means both internally consistent and, probably more importantly, consistent with previous reports that the expert has delivered. So it's not uncommon in these cases that you'll receive a report number one after discoveries. You'll then get reply reports from the defense, and you'll ask your expert to prepare a further report dealing with the issues raised by the defense experts. So it's important that you make sure that that second report or even third report is consistent with what the expert has said beforehand so that they don't run into trouble. The report must be fair. That is, the opinion has to be fair. They can't misstate the evidence, they can't misstate the records, and they can't misstate the literature. And so, you have to, again, test the opinion and make sure that it is reasonable. And then lastly, the contents of the report have to be fully within the scope of the expertise of the expert. So experts are not retained for the purpose of deciding credibility contests. In the scenario that I mentioned earlier, where you're asking the expert to assume a different version of events, it is not for the expert to comment on which version of events is correct. Similarly, if the expert is qualified as a general surgeon, they probably can't weigh in on the interpretation of pathology or something else. So make sure that it is within the scope of their expertise. If there is any literature which supports the expert's opinion, it should be explicitly referred to in the report. It is always good practice to ask the expert whether there is any literature, whether that's in the form of textbooks or articles from reputable sources, that they can refer to or rely upon, and have them actually cite it so that you will be able to put that literature into evidence at trial. If it's not referenced in the report, you may be able to put it in through your expert, but probably not. You may be able to put it in through the defendant's experts, but not if they won't accept the authenticity of it or the authority of the literature. And so you want to make sure that your expert is citing anything which is going to be helpful to your case. These cases often turn on the literature, right? A judge has to decide between expert A and expert B, both of whom are very well educated, will have been very experienced, probably presented reasonably well in the box. And so, the judge is going to be looking around at anything external to the process to try and assist with deciding which opinion is to be preferred. Literature is a huge factor in these cases, and so having your expert review the literature and reference the literature really is a huge advantage. Lastly, I've talked about receiving draft reports. You should assume that all drafts will be produced. Now, there was a time in which that was done as a matter of course. That's not the case right now. But nevertheless, even today, there is always the possibility that the expert's drafts will come out and will form the basis of cross-examination at trial. And if you have made significant and substantial edits to that report, that may be fatal to the expert's opinion and to the credibility of their opinion. You only have to see that cross-examination once to never want to see it again. So it is acceptable to suggest changes, to point out corrections and so on to experts, but always do that with the understanding or with the assumption that the drafts are going to be produced. And so if you are asking the expert, just to fix up dates or times or whatever, that's probably going to be fine. If, on the other hand, you're asking them to say that black is white, to change a yes, a yes to a no, just think of how that is going to play out if it comes to light. And if it is something so significant and so material to the expert's opinion, you may be better off getting a new expert altogether. All right. So preparing the expert for trial, I would suggest that that involves two essential steps. Number one, which is the harder one, is prepare yourself. And then once you've done that, prepare the expert. To prepare yourself, you have to read everything. You have to read all of the productions, of course. You have to read all of the reports that have been delivered. You must read all of the literature that has been identified by any expert. So if your expert has cited a bunch of literature, as I talked about, you need to make sure that you have read it, and actually you should make sure you read it before that report is finalized to confirm that it actually says what the expert says it says. And you must read any literature identified by the defense experts, and you must read those articles very, very carefully. You should look through the CVs of all of the experts, and if anybody has written anything which is relevant to your case, you need to get that and read that. In your own experts, you want to make sure that they have not written something which is inconsistent with what they're saying now, which is going to be the basis of cross-examination. And in the case of the defense experts, you want to see whether there's anything that you are going to be able to use. And then you should also do a literature search yourself and read any other relevant medical literature on the issues in the case. It is critical that you understand what the defense argument is. If you are going into trial, there will be an argument that the defense is advancing, and you need to understand it. And you need to understand it so that you can prepare your expert to deal with it. You should not assume that your expert is going to do all of this for you, right? They're very busy. Some take testifying more seriously than others. Many experts have been retained lots and lots of times but have never testified, and so they just assume that the case is going to settle. And so you can't assume that your expert will be fully prepared. You've got to do it yourself. You've got to do the hard work. Once you have done that, you're in a position now to prepare the expert. And so what you need to do is you need to ensure that the expert has the facts firmly in mind. They need to know the case, at least insofar as it's relevant to their opinion. They need to be familiar with the medical records. And they need those things so that in cross-examination, if something is suggested to them which doesn't accord with the facts or doesn't fully capture everything, they will be in a position to respond and not leave it to you, hopefully being able to deal with it in re-examination. They need to have read all of the literature again that they have cited, so they're going to need to refresh their memory and reread all of that literature. And probably more importantly, they need to read all of the literature that was relied on by the defendants, and they need to be prepared to deal with it. And so the way that you can ensure that is by understanding it yourself and then asking them specific questions about what those articles say, what the opinions are that are contained in them, and so on. Again, you need to anticipate what the cross-examination is going to be, and you need to prepare the expert to respond based on the literature and the evidence in the case. Again, the more they can anchor it into something external to just their own opinion, the more likely their opinion is to be accepted. Fundamentally, the expert should not be surprised. And if you do all of those things, you should be successful. If anyone has any questions, please feel free to contact me. My coordinates are there, and I hope you guys all enjoy the rest of the conference. Thanks.
Hi, everybody, and thank you for joining us for this session of our presentation. I'm pleased to be here today with Richard Halpern, and we are presenting on the topic of what happened to my baby. I'm going to go ahead and share my screen with all of you, so hopefully this works. I just wanted to make sure that I would be able to speak to you today from the perspective of someone who has been through this situation with my son. So for those of you who do not know me, my name is Brenda Agnew, and I am a client liaison with Gluckstein Lawyers, and I've been with the firm for about 3 years now, but our relationship goes back to about 2009 when I first walked through their doors with a bunch of questions, and one of those questions was, what happened to my baby? So without going into a lot of detail, for those people who are not aware of my story, I'll tell it very, very briefly because I don't want to spend too much time just speaking about myself, but I do have two boys, and my younger son, McLean, has cerebral palsy, and his cerebral palsy was as a result of a medical negligence situation. And that's what really has brought me here. And so I have walked the walk and been in the shoes of hundreds of parents who have been in a very surprising and unexpected situation. When this happens, and I get asked this a lot, but when this happens, there's a number of sort of emotions that go through your head. So, you're expecting a child, you have that child, you don't anticipate for the most part that anything's going to happen unless you've been given some indication prior to the birth of your child that there may have been something going on in utero, or there may be something, that's been picked up on a scan. For the most part, you read the pregnancy books, you eat how you're supposed to, you do the things you're supposed to, and you cross everything that, your child is going to come out healthy as can be. And when you run into a situation where perhaps there has been a traumatic birth that has happened, or something that has happened in the neonatal period, it could be something that happens shortly before birth. I think the initial is you're overwhelmed. You've got this new baby, and then on top of all of that, you possibly have a child that's dealing with a lot of issues immediately upon their birth or shortly after their birth. So overwhelmed is the best way I feel to describe the situation when it occurs. And with that comes a lot of confusion. So you're very unsure as to what's transpiring, what's going on. There's often a number of doctors and nurses in the room at the time that it happened. Or maybe it's later on that you receive a diagnosis that was unexpected. So perhaps your child is born, and maybe there's a little something that happened, but it's not really apparent. And it's a little while later, they're not meeting their milestones, something's going on, and they receive a diagnosis, let's say, of cerebral palsy. And you're completely confused because, again, it's not something that you were expecting. It's not something that you were ever anticipating, and it hits you out of left field. And, often we find in these situations that there's little or no information from the physicians that, we've dealt with or have been dealing with. If it's a situation where something has happened at birth, we're often told, these things just happen sometimes. That's the risk of labor and delivery. Things happen, and we don't always have an answer for them. And we often hear that later on when diagnoses are given. And I know so many parents who get a diagnosis, again, of cerebral palsy for their child as an example, and they'll say to the doctor, what happened? And usually the person giving the diagnosis has not been the person that delivered them. So they will have no concept of what transpired at the time of the birth, if it was a birth-related injury, or if it happened in the neonatal period. You could be dealing with a developmental pediatrician who just, honestly puts their hands up and says, I don't know, these things just happen sometimes. And so, there's often not a lot of answers that will come forward. And I've seen parents even request MRIs and be denied that because they're often told at the end of the day that an MRI, regardless of what it shows, is not going to change the outcome of what the child is dealing with. So, you know, we're often overwhelmed, we're confused, and we have little to no answers. And so when all of that happens, I find that for most parents, and myself included, it brings you to a situation where there's a bunch of questions that you are now faced with. You're now faced with, I guess is the best way to describe that. You know, what happened? You know, when we encountered the situation with our son, that question, it still comes up, but that question came over time and time again is, you know, what happened? So whether that's at the immediate time that this has transpired, so you've had a child, something's happened during labor and delivery, maybe the child is having seizures after, they're spending some time in the NICU, you're going to ask, what happened? You know, how did this happen? Why did this happen to my child? It might happen later on. They're not meeting their milestones. You know, they're seeing some developmental delays. You're seeing some things that are out of the ordinary, and you know, you're asking a doctor what's going on. Your pediatrician, your developmental pediatrician. There's a referral made, and again, what happened? You know, you're given a diagnosis. How did that happen? How did they get that? And which leads into, you know, questions like, again, could what have happened have been avoided? You know, once there's some determination or some discussion around, you know, what may have happened to your baby, could have this been avoided? Everybody wants to know that. Should I have eaten, you know, mothers take on a lot of guilt. Should I have eaten less sushi? Should I have had more rest? You know, we know that in the majority of cases, this is not something that has happened as a result of something that the mother has necessarily done. But you're going to ask the question to know that could this have been avoided? And whether that was something that, you know, that as a mother, you want to know that it could have been avoided, or was it something that a physician did that could have been avoided? And what does this mean for the future? So you're given this diagnosis for your child. What does this mean? Not only what does it mean as far as the disability that they may be facing, but, you know, what does this mean for the care that they need to receive? What does this diagnosis mean as far as what you're facing for interventions, medications, treatments, all of those sorts of things? And then, of course, all the questions, you know, what's going to happen for their future? Will they work? Will they have a fulsome life? Will they have an ability to earn? How will we pay for this? What happens when I'm gone? I think that's a natural progression for parents when they realize that something has happened to their baby and they've been left with a devastating diagnosis and all that comes with that. We know that children who have conditions like cerebral palsy, you know, the life for the family, there's a huge impact on the family, financially, emotionally, physically. So what does this mean for the future as far as the diagnosis they're facing with their child? And I mean, ultimately, you know, we're here for a conversation around medical malpractice and medical negligence and what that means for families. So, you know, the next question I'm often asked, and I know that I asked, is, you know, how can a lawyer help me here? You know, is this something that I need to do more with? Is this something that I need to take forward and have someone take a look at this? And that's a question that, you know, I can't answer for somebody other than to say, and I'll just move to my next slide, but other than to say, you know, trust your instincts. So when parents come to me and they say, Brenda, you know, I think this has happened to my son. He has this diagnosis. We don't know what happened. We have our suspicions, but sometimes we're really not sure. You know, did somebody do something wrong? What do I do now? And I often say to them, you know, trust your instincts. If you think that something has transpired that has affected your child and has left them with a devastating diagnosis, and that's what your gut is telling you, I say you need to trust your instincts. You know, don't be afraid to ask the questions. Ask the questions, not just of the lawyer, ask the questions of the physicians. You know, do some digging. Find out as much information as you can. And then, you know, also don't be afraid to ask lawyers those questions. That's what the law firms are there for. That's what the lawyers are there for. They're there for you to ask those questions too. And, you know, Richard's going to talk a little bit probably, I'm putting him on the spot here, but he often speaks with our new clients that come in when they ask the question, what has happened to my baby? And lawyers are in a position where they're able to assist families in answering those questions to the best of their ability. You really have nothing to lose. I believe wholeheartedly that lawyers and their team, when you have these conversations, can help you turn that page. And it may not be an answer that you want to hear or an answer you're hoping to hear, but they certainly can help you investigate in many situations what has transpired and what has happened to your baby. And the big thing that I wanted to comment on before I sort of turn this over to Richard to comment is, I hear a lot from parents who say, I feel bad. I feel bad because I really liked this doctor. I really liked the hospital that I was at. I really liked the nurses that were helping us, and I feel bad, and I don't want to get anybody in trouble, and I don't, I know that my son may have disabilities for the rest of his life, and I'm questioning why that happens, and I'm worried about the future, but I don't want to get anybody in trouble. And to this I will say, and I've had a doctor say this to me directly and question me on my motivations and intentions behind seeking legal action when things happen to my son, is your loyalty is to your family and your loyalty is to your child. And we can get into the details about how the doctors and the hospitals are protected by different mechanisms as far as insurance and whatnot is concerned. But this is your child, this is your family. You want to make sure that you can give them the best life possible, that you can provide them with all of the resources and support that they may require as they get older and as their life changes and your life changes. And I think you need to keep that top of mind and not worry about really anybody else other than your family. And again, back to the top, trust your instincts. Don't be afraid to ask the questions. You really have nothing to lose. And hopefully having a conversation with a lawyer can help you turn the page on the question of what's happened to my baby. And I'm going to send this over to Richard. I gave him probably a lot to think about.
Thanks, Brenda. And your insights are what we see and what we hear in all the cases that we come across. I still find it remarkable that virtually every time I see young parents come in with a birth injury case that they ask, what happened to my baby? Even years after the injury occurs, they seem to be asking, what happened to my baby? They don't have the answers. Sometimes they have a vague understanding, but they really have a diagnosis with no appreciation for when or how their baby got hurt. What they are told are sometimes maybe vague and misleading answers from care practitioners. And I will talk a little bit about why that happens, but you've touched on some of them already. We don't know how your baby got hurt is a common answer. Or cerebral palsy is often unavoidable, what they call idiopathic, without known cause. Or science can't explain why some babies get cerebral palsy. And they go on to say that, looking back at what happened during your labor and delivery, quite frankly, we would not have done anything different. These are not good answers. These are the most unsatisfactory answers that you can get. And no parent should be satisfied with it. So in the obstetrical community, I think what we've learned is that there's this notion that newborn neurologic injury often occurs before labor and delivery. So around the time of labor and delivery is called peripartum, during labor is called intrapartum, and before is antepartum. And if you read the medical literature, you will find that virtually everywhere it talks about the vast majority of newborn neurologic injury occurs as a result of antenatal events and therefore is unpreventable. And this data that the scientists rely upon actually is not reliable data. It is outdated data, and it should not be satisfactory to any parent. It is not an explanation for what happened. So I'm going to go through a little bit of what I consider to be a causation algorithm about how we figured these things out. But the fact is that the data that suggests that most of the injury is antepartum, as I said, is dated. And what we have in the last, I'm going to say last 10 years or so, is improvement in neuroimaging. So taking pictures of the baby's brain, usually in the first days and perhaps a couple of weeks of life, that is very sensitive for picking up acute or recent injury. So neuroimaging, what medical science can now do is tell you when the injury occurred and how the injury occurred and whether it's acute. And more recent data has demonstrated that, in fact, most newborn neurologic injury is peripartum. It occurs at or around the time of birth. This is not something the obstetrical community has willingly accepted or acknowledged, and they still don't. And I'll be talking a little bit about guidelines from the SOGC later. So I want to touch on the problems with disclosure. A patient has a right of disclosure from their healthcare practitioner related to anything that is adverse, any adverse outcome. And I question whether full disclosure is being made. I don't attribute fault necessarily to the physicians, and I'm going to explain why. I attribute fault more to the system and how we address disclosure to parents about what happened to their babies. But what's the typical scenario when a baby is hurt during labor and delivery? The mother, during her pregnancy, is treated by Dr. Smith for her antenatal care. But Dr. Smith is not the doctor who's going to deliver her baby. She goes into labor, she goes to a local hospital, and the obstetrician on call is Dr. Jones. And Dr. Jones, whom she has never met, is going to deliver her baby. If that baby is born in a depressed condition and is in need of some serious help, baby gets transferred, say, to the hospital for sick children, as an example. Dr. Jones doesn't know the outcome. So many depressed babies actually do not go on to suffer serious injury. They get resuscitated, they get treated with a therapy called therapeutic hypothermia, whatever happens. These babies get treated and they do not go on to develop problems. Or they do develop problems, but they're not diagnosed for years to come. So diagnosis of cerebral palsy may take a couple of years to do, but not all babies injured in labor suffer cerebral palsy. So cerebral palsy is a motor disorder. And some babies suffer non-motor dysfunction as a result of these events, and they may not be diagnosed until school age 5, age 6, even later sometimes. Because we've come to discover that asphyxial events that occur during labor and delivery can result in neurodevelopmental problems, cognitive problems, and behavioral problems, perhaps even autistic type behavior. Later in life, that is not detected until quite a bit later in life. So CP is not the only measure of outcome for babies that are asphyxiated in labor. So Dr. Jones, who delivered this baby, doesn't follow up what happened. Dr. Jones doesn't know that she has an obligation to tell the parents anything because she never sees the parents again in that situation. One of the questions I often ask is whether or not there is some obligation on the part of people, that is physicians, subsequently involved in the care, to disclose to the parents what happened to their baby. Neonatology, pediatric neurology, developmental pediatrics. Is there some obligation on them to tell them what happened, even though it is not their conduct that resulted in the adverse outcome that affects their baby? I mean, it's a nice question. I can tell you that it's my sense that the medical profession is specifically told not to comment on the adequacy of care provided by other people earlier in the chain of events. So I think that's problematic, and I think at some point the system needs to better address the issue of disclosure to parents in these situations. The result is that when parents come in to see me, sometimes I'm the first person to tell them what happened to their baby. I'm not a doctor, so I'm not really qualified to do it, but I've seen enough of these cases that I can, in most cases, certainly know that if a child has been injured during labor and delivery, 9 out of 10 times I'll be able to tell that from my own review of the records. I would review the labor delivery records, the antenatal records, newborn records, and the tracing, and I'll be able to tell the parents. Now, I obviously qualify my views about what happened to the baby by saying it needs to be verified by people who are better qualified than I am to talk about these things: obstetricians, neuroradiologists, neonatologists, sometimes placental pathologists, and that kind of thing. Geneticists, some genetics often comes up in these cases as well. So we have to be concerned about genetics as well from a causation standpoint. So what I do is when a new parent comes in, I get their story, but the first thing I want to do is I want to get the records, and I want to review them. I want to see the labor delivery records in particular, and the tracing, and I can usually tell what happened to the baby just from reviewing those records. But what I want to address here is what do the parents want to know? And you've touched on this already, Brenda. The first thing is they want to know when my baby was hurt. I call that the timing. And how my baby was hurt. I call that the mechanism of injury, the timing and mechanism of injury. And there is no well-defined causation algorithm in the medical data about how we make that determination. But I suggest that all the elements of a very good causation algorithm are available to us if we pay attention to them. And what are the elements? So I maintain, number one, that the first step in determining what happened to your baby is neuroimaging. Always start with neuroimaging. And I will tell people that in the first days and couple of weeks of the baby's life, there will be scans. If the baby is born in a depressed condition and is in need of help, there will be scans of the baby's brain, ultrasounds of the baby's brain, perhaps a CT scan of the baby's brain, or best, serial MRIs of the baby's brain. And the neuroimaging is going to tell us a couple of things with precision, with good precision, and with certainty. Number one is, actually there's three things. Number one is there a remote antenatal injury? Is there any evidence on the brain of an injury that occurred long before the baby was born? The answer in most cases is no. Number two, is the injury acute? It is the kind of injury that occurred at or around the time of birth. And they know that because brain injuries go through a certain process, an evolution in the first 2 weeks of life, especially with cerebral palsy. They go through an evolution, and that evolution is well known. The evolution being initially nothing in the first 24 hours of life. Usually, it's you do an ultrasound in the first 24 hours of life, you see nothing. And then after 24 hours, unless it's very acute, and then after 24 hours, you see swelling in the brain, edema, and that edema gets worse over 3 to 5 days, and then it resolves after 7 to 10 days in a very specific pattern. And that demonstrates what we call an acute injury. Those injuries had to have happened at or around the time of birth. There's no debate about that. And then once we do that, and we know it's acute, that doesn't mean somebody's at fault. That only tells us when it occurred. It doesn't mean there's negligence. It just tells us when the injury occurred. And then when it resolves, the pattern of injury that's seen on the brain and the areas of the brain that are injured tell us about the mechanism, what caused the injury to the brain. So we must make a distinction between sort of widespread diffuse injury in the brain, which tells us it's probably asphyxia during labor, as opposed to focal or isolated injuries, which may not be due to asphyxia in labor. Stroke sometimes causes those things. But what my message is that causation algorithm always starts with neuroimaging. And the other thing I'd like people to pay some attention to is that electronic fetal monitoring, and this is controversial, and I can explain another time why this is so, but electronic fetal monitoring will help us define or refine the timing of injury. So neuroimaging gives us a window of opportunity, sometimes days, hours, sometimes weeks, depending, but it could be as little as days or hours. And then to determine when in those days and hours injury occurred, we can look at electronic fetal monitoring, and it will tell us. It will refine the timing of injury, despite denials from many in the obstetrical community. It actually will do so. And then the final step in the diagnosis, and what I tell people, is applying the differential diagnosis. So what is a differential diagnosis? If we come up with a list of possible causes for what we see, then we must go through those things and eliminate the ones that probably didn't occur and land on the one that is most likely to have occurred. That's the differential diagnosis. So that if we've identified a window of opportunity for injury to occur on neuroimaging, if we've taken the second step and then we have narrowed the window of opportunity by using electronic fetal monitoring or heart rate patterns of the baby during labor and delivery, then we take that interval, that time interval, and we ask a simple question. What occurred during that time interval that can explain the outcome for this baby? Was there trauma? Was mom involved in an accident? Was there a rupture of her uterus? Were there genetic issues? Did the baby come into labor delivery indicating that it was neurologically intact and healthy and vibrant and well and resilient? And did the tracing deteriorate and become abnormal over the course of the labor and delivery? These are the things that will allow us to focus on the actual cause and the actual timing. And then once we have that, we can ask the question, did obstetrical, nursing, or midwifery care somehow cause that? Was it avoidable, as you put it, Brenda? Was this avoidable injury? And that's what the parents want to know. And if it was unavoidable, as some are, at least as a parent, I think you're accepting of that. Once you've done your due diligence and you've looked after, as you say, your family, and you've done all the work that you can, but done this analysis in the way that gives you an actual answer and not these speculations, well, we don't know, it's idiopathic. None of that's acceptable. But once you make this inquiry, and if you're told after that inquiry has been done that the injury was not due to negligence, it didn't occur during labor and delivery, then at least you've done your duty and you've done your due diligence. On the other hand, if it is a result of somebody's mistake, then you and your family are entitled to compensation. So that's essentially the process that I go through, not only with my clients and with reviewing the records, but with my experts too. I take them through that very same exercise. So that's essentially my approach.
Well, and Richard, as you're talking, I mean, you know, I always make notes, and I tell you this every time we talk, you know, something always comes up that I want to comment on because you hit so many nails on the head. But, you know, one of the things I think is really important, and you spoke about this, and I want to reiterate for any of the parents that might be listening or any of the physicians that might be listening, more to the point as well, is when parents are asking questions, you know, when they're going through this, they're not placing blame. I feel, you know, we had asked so many questions along the way of every doctor we could get our hands on because I wanted to know what happened. I had this, you know, I mean, listen, my situation was a little bit different and without a lot of detail. You know, McLean wasn't your typical healthy child who was affected during labor. Okay, so, you know, I know that, you know, he came out, he was premature, he had twin-to-twin transfusion. There was a bunch of things going on, I'm not going to lie. But as you said, you know, you start to check off those differential things and you're like, nope, 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 nope. But every question we asked, it wasn't a blame-filled question. It was, what does this mean? And why would you think he has this diagnosis of hearing loss? And why is he not meeting his milestones? Why does he seem hypotonic to you? Is he going to walk? Is he going to, could something have happened during my labor? Could something have, because you want to know when you're trying to put together, what therapies do I want to approach? What referrals do I need? What doctors do I need to see? And so when I asked those questions, I just wanted to get answers. I wanted legitimate answers, just like you would for a typical child when you say, why does my kid keep getting ear infections, right? Why does my son always get strep throat? You ask these questions because you're a parent and you want to know. And obviously that's more heightened when you have a child that has some sort of diagnosis that was unknown. So, you know, that was a lot of the frustration that I had, is I just kept asking these questions, and at every level and at every layer, back to your point about the inability often for families, patients, parents to have access to records, that is an extremely frustrating part of the system. But, you know, and it was, again, you know, Richard, it was the non-answers that led me to call the law firm. And I got more answers through the systematic process that my team went through by analyzing the records, by speaking to experts. They gave me more answers than I would ever have gotten through the physicians that were on my team. And that's a really hard place for a parent to be in, especially if they don't have the tenacity or the energy to continually ask those questions. And when I heard you say that, it just brought up all of these thoughts of what we had been through those first few years.
It's interesting what you say, Brenda, about blame. And often when the medical community is looking at this, they say they want to avoid a culture of shame and blame. But let's put it another way, because I think that the medical community does themselves a disservice by focusing on this avoidance of a culture of shame and blame. If I were to counsel doctors, the first thing I'd tell them is make full disclosure. Tell the patient everything. It's your obligation, and do so without regard to legal liability, because legal liability ought not to dictate how doctors conduct themselves, number one. But shame and blame is a spin, and there's another side to that coin. The other side to that coin is, number one, accountability. Those who do not provide care according to acceptable standards ought to be accountable. Number two, our tort system, I think, is a very important system about the burden of loss. Where do we shift the burden of loss? Do you, as a parent of one of these children, always bear the burden of loss, or should the wrongdoer bear the burden of loss? I think that's another thing. But the final thing, and I think the thing that maybe hopefully people on both sides of this issue share, is about improved care. It's about avoiding bad outcomes. So when we identify what went wrong and why it went wrong, only then can we fix what went wrong. Only then can we establish guidelines and ways of improving intrapartum care so that fewer babies are born with cerebral palsy or other disabilities that arise out of asphyxia. And I think that's got to be the focus.
And that is a great way to sum that up. And, Richard and I could talk for hours about this. We're both very passionate from different perspectives, but you're right. At the end of the day, I think the goal of everybody here is to not only try to assist those families who unfortunately have been through a situation, and this is something that you've made your life's work out of, but let's take that one step further and let's actually, let's look at avoidance. And, some of the best doctors that I have ever dealt with say to me on a consistent basis, I wish that I didn't have my job. I wish that I didn't have kids with cerebral palsy that needed me to help them. I wish that there was less kids coming through my door. And I mean, at the end of the day, if there's things that we can do through this process and we can shift that mindset and really take a look, like you said, at, if something has happened and we can change a guideline, we can change a protocol, we can maybe avoid that from happening next time. Why wouldn't we do that? These are our most vulnerable. And when somebody sees what a family and a child goes through with these devastating diagnoses, I think that that's really what rises to the surface for me is let's try to make sure that this doesn't happen to the next baby, that comes along. So I want to thank everybody. You will be seeing a lot of Richard in our conference. I think we have to change our marketing to the Richard Halpern Show. But we joke about that. But in all honesty, I mean, this is a great conference. A lot of great information, and Richard will just bring a lot of expertise forward. And so I thank you for presenting with me today, Richard. It's always a pleasure to speak with you.
Thank you, Brenda.
And we look forward to your next presentation. So thank you, everybody, for being a part of this one, and we hope you enjoy the conference.
Hi, everybody. Richard Halpern back again. I'm going to be talking about medical literature in this talk, and you can see by the title page of my presentation that it's about fetal surveillance in labor, and I'm going to be talking very specifically about a new guideline that came out of the Society of Obstetricians and Gynecologists of Canada in March of this year about how to monitor babies during labor. I've written a paper, a rather long and dense paper, and this slideshow unfortunately is a little long and dense as well, but I've written a paper about why I'm critical of the SOGC guideline in a number of very important ways. And that paper is available to you if you go onto our website. The comments that I'm going to make specifically in this talk have to do with fetal surveillance, but I want to start by talking about medical research and experts in more general terms, because I think that what I talk about in this discussion about fetal surveillance and the SOGC guidelines really applies to all of the medical malpractice cases that we might prosecute on behalf of our clients. Let me give you an example. You may have a causation expert, and I don't care whether the issue is late diagnosis of cancer, it could be surgical misadventure, it could be any kind of delayed diagnosis. It really doesn't matter what it is. Every case is concerned with causation. And you may ask your expert, what would the outcome have been for my client? In other words, had the negligence not occurred, what would the health trajectory have been for my client? Can I prove on a balance of probabilities that the patient is worse off as a result of the misadventure? That's not always easy, particularly for those of you who do cancer cases or surgical cases. You know that that's not easy. Let's say that your expert comes back to you and says, I've done some research and 60% of these patients do poorly. You haven't met the burden of proof of a balance of probabilities because 60% of them do poorly, and on the surface of matters, you lose your case. But you as an advocate must go and look behind what that expert has to say. In many of these cases, the experts will rely on epidemiological research. That means that they are looking at large cohorts of patients with different characteristics, and it may be age, it may be pre-existing health, it may be places where they live, it may be socioeconomic, it doesn't matter what it is. But the cohort or the group of people that your expert has looked at to suggest that the prognosis was gloomy for your patient may not be representative of your client. And this is the point that I want to make. If an expert tells me that there's a 60% chance that there would have been no difference, I want to go look at the literature that the expert relied on and take a critical look at it. If the cohort of patients involve people who were predominantly older, say over 60, although that doesn't sound so old to me anymore, but let's say the cohort of patients is over 60 and your client is 20 years old, then the conclusions in that study may not apply to your client. So that the variables that these large studies look at to come to a conclusion about the likelihood of an outcome must be taken into consideration when determining whether or not it applies to your case. And so in many cases that I've had, I've been able to demonstrate that the epidemiological research has no application to my client. And that kind of research was never intended to apply to your client. You know, I think in the motor vehicle field, we hear about all this science-based, experience-based, whatever the term is, research. It doesn't apply to individuals. I think that's the important thing. Another example would be in a case where my young client had an infection and the treatment guidelines said that the duration of antibiotic therapy is between 2 and 4 weeks. That's all the guideline says. And in my case, they stopped therapy at 2 weeks. My client went on to have a relapse and suffered severe brain damage. My expert said, well, they were within the range of the recommendation for the duration of therapy. What do I have to complain about? And by looking at the research, the answer is some patients need 2 weeks of therapy, and some need 3 weeks, and some need 4 weeks of therapy. And the point is, what are the clinical variables, whether it's age or presentation, that make it different for your client such that the therapy should have been extended for 3 weeks or 4 weeks? Again, we need to take a look carefully behind the literature. In the talk that I'm going to give now, I look specifically at fetal surveillance in labor and what the SOGC has had to say about that subject. It is my view that the guideline has oversights, omissions, and has squandered opportunities to improve fetal safety, and I'm going to go through some of that. And again, let me apologize in advance for how technical this talk is, but I think it's an example of what we as lawyers must do to properly advocate for our clients in these very complex and difficult cases. The guideline from 2020 replaces a guideline from 2007, so certainly a new guideline was long overdue. It may be important to note that the 2007 guideline actually dealt with more than just intrapartum or during labor fetal surveillance. It also dealt with antepartum or prior to labor fetal surveillance. So it certainly is not a replacement completely for the 2007 SOGC guideline. What we're concerned about when we talk about fetal surveillance, for those of you not familiar with birth trauma cases or birth injury cases, is we're concerned about evaluating fetal oxygenation during labor, and that tells us something about fetal well-being. A well-oxygenated baby is not going to suffer injury during labor. And the way that we measure a baby's oxygenation primarily is through the fetal heart rate. So there are certain patterns of the fetal heart rate that indicate a baby who is doing well, and certain patterns of the fetal heart rate that suggest the baby may be stressed as a result of labor. And labor is a stressful time for the baby. Each time the mother's uterus contracts, the uterus is a muscle, it squeezes the blood vessels and slows the supply of oxygen to the baby. And then when the uterus relaxes between contractions, the flow of blood is restored, and therefore oxygenation of the baby is restored. We also know that babies are very resilient, so that they can withstand considerable intermittent interruptions of oxygenation, provided they're given enough recovery time between contractions. But a baby's resilience is not unlimited. The baby's tolerance to this kind of stress can be taxed. And what we call fetal reserves, the baby's ability to withstand these episodes of decreased oxygenation, can eventually become overwhelmed if nurses and doctors don't do something about it. So the issue is, how's the baby doing in terms of oxygenation? Is the baby coping well with the stress of this labor? Is there any reason to be concerned about the baby based on the heart rate? And ultimately, the question that has to be asked every time a nurse or a doctor takes a look at this clinical scenario is it safe to allow this labor to continue? What is the feasibility of a safe vaginal delivery? That must be asked each and every time, or at least considered each and every time the nurse, the doctor, the midwife looks at the fetal surveillance data. So why has a lawyer written a critique of an obstetrical guideline? And the answer is nobody else is going to do it. Most obstetricians are members of the Society of Obstetricians and Gynecologists, and it's not a popular cause for them to take on. I can tell you that in preparing my paper, I have talked to a number of obstetricians, and they certainly shy away from the idea that it might be appropriate to criticize a guideline coming out of their own association. But I'm going to talk about, for those of you who are involved in birth injury cases, who might be involved in birth injury cases, or who just want to understand how a lawyer might take on questionable science in the area that they're looking at. I'm going to tell you how I've taken this on, and if you want a detailed analysis or a complete cure to insomnia, you can read my paper. So experts in these cases, particularly in obstetrics, rely heavily on SOGC guidelines. And an expert in any one of your cases might cite the SOGC 2020 fetal surveillance guideline as authority for one proposition or another. And there are problems in the SOGC guideline. I am not going to get into all of the technical difficulties, but there are conclusions, in my view, that are expressed in the SOGC guideline that are either weakly supported by the data or not supported by the data at all. For example, some of the things not adequately supported by the data are the idea that accelerations of fetal heart rate no longer have much of a clinical significance. It was previously thought that if the baby's heart rate went up as it was being monitored, it was a sign that maybe the baby was doing well, a positive sign of fetal oxygenation. In the old guideline, you needed to see accelerations in order to be reassured that the baby was coping well, but in the new guideline, that's not necessary. I don't think that SOGC 2020 has cited adequate science to support the conclusion that one need not see accelerations in order to be reassured by about fetal well-being. The other thing about acceleration is there's another way to elicit an acceleration from a baby, and that is if the baby is descended sufficiently in the birth canal, you can stimulate the top of the baby's head. You can just poke the baby in the head, and if you elicit an acceleration, that tells you the baby's well oxygenated because it is associated with good oxygenation of the fetus. The new guideline talks about that, and it's very difficult to reconcile their conclusions about not needing accelerations, yet being reassured or potentially reassured by stimulation of the fetal scalp. So that's a problem. Early decelerations, I'm not going to get into the details about early decelerations except to say that I don't think there is science to support what SOGC says about early decelerations being always benign and never of concern. And you'll have to read my paper to get some idea about that. One of the important things in this third bullet on the slide is the issue of intermittent auscultation versus electronic fetal monitoring. So there are two ways in which the baby's heart rate can be monitored. One is to listen, essentially with a stethoscope. It's not really a stethoscope, but to listen on the mother's belly occasionally, or intermittently, after a contraction and for a period of 1 minute to hear the baby's heart rate. And then if everything sounds reassuring for the minute following the contraction, it's okay to wait to the next contraction to do it again, or 15 minutes later to do it again. With electronic fetal monitoring, however, you get a continuous printout, and I'm going to show one of those in another presentation, but you get a continuous printout of the baby's heart rate on a graph paper at the top, and then below that a continuous printout of the maternal contractions. And so that you have uninterrupted and continuous monitoring of the baby's heart rate that can be evaluated any time. What's the advantage or disadvantage of intermittent auscultation versus electronic fetal monitoring? Well, the guideline says that it's okay to use intermittent auscultation in low-risk pregnancies. I maintain in my paper that it's never okay to use intermittent auscultation. The guideline relies on certain literature, and I suggest in my paper that the literature does not support the conclusions about intermittent auscultation. It's an uphill battle to fight this, and most babies are monitored using electronic fetal monitoring in any event. But the new guideline continues to promote intermittent auscultation as an appropriate method of monitoring the fetal heart in a low-risk labor. You'll see in my paper why I take issue with that and why I say that the literature that they rely on is not supportive. The other thing about intermittent auscultation is that it reveals less data about fetal well-being than does EFM. And my view is that I don't believe that less data is better than more data. The people who support intermittent auscultation will tell you that with electronic fetal monitoring, you get more interventions in the way of cesarean sections, and that's dangerous for mother and baby. Again, I don't accept that notion. The other notion that is promoted by people who promote intermittent auscultation is that electronic fetal monitoring results in too many what they call false positives. And what's a false positive? Too often, the tracing is read as being indicative of fetal stress, and intervention takes place, say, in the way of a cesarean section. Baby's delivered, the baby's okay. So actually, the tracing wasn't so bad because the baby was okay. But that betrays a fundamental misunderstanding of the purpose of monitoring the baby during labor. The purpose of monitoring the baby during labor is to get an okay baby every single time, so that electronic fetal monitoring used properly will get a normal baby every time, and it will be falsely positive every time. If you get a true positive, that is, if you think that the tracing looks bad, and you deliver the baby and the baby is in bad shape, that would be a true positive. It means you waited too long. It means you didn't use electronic fetal monitoring properly. It suggests negligence. So true positives in the use of electronic fetal monitoring are a bad idea. We want to get a false negative each and every time. And there is an enormous amount of literature on this in the obstetrical writing that refers to this false positive notion as a negative of EFM, when it is not at all. This is something that we need to know and that we need to understand as lawyers, because it's something that has been sold to the obstetrical community that just isn't right. And if we're going to properly represent our clients, then we have to understand this issue and have a very careful discussion with our experts why that doesn't matter, why it isn't important. The other thing that opponents of EFM say is that different people looking at the same fetal heart pattern will come to different conclusions, what they call inter-observer variability. They also say that even the same person who looks at a tracing and then looks at it sometime down the road will contradict themselves, or called intra-observer variability. There are a number of papers that have been written on the subject in the obstetrical literature, and those papers are seriously deficient. I will go so far to say that those papers are junk science, and I'm happy to explain why that is the case to anybody. They're old, they're dated, they ask the wrong questions. So we need our experts to understand why, even if the obstetrical community promotes those notions, those are tired notions that are not worthy of any more respect. Some of the recommendations in the guideline are vague and imprecise. So I talk about the overall clinical picture. One of the things about babies, and this is the case not just in babies, but all kinds of cases, is that you have to look at all of the clinical variables that affect assessing fetal health. It isn't just the fetal heart rate. It's the progress of labor. Is it progressing like it should? It's the condition of the mother. Does she have a fever? Is she getting exhausted? It's the position of the baby. Is the baby in the correct position to pass through the maternal pelvis, or is there some sort of an obstruction, what we call a mechanical problem? Are her uterine contractions in the normal, occurring normally like we like them to see, or like to see them? They may not be. Are they occurring too close together? Is the uterus soft or hard between contractions? Are they too long? You have to evaluate all of these things, and this new guideline talks about the overall clinical picture, but offers very little to practitioners and how they would go about assessing the overall clinical picture in labor and delivery. So it's really quite deficient in that respect. The new guideline has a a new interpretation or a new definition of the term that is used to describe too much uterine activity. It's called tachysystole, and they describe all forms of abnormal uterine activity as tachysystole. Look at my paper. That's an inappropriate definition. It is an imprecise way for nurses and doctors to communicate about labor, and that really should be changed. I also mentioned here some issues about variability and decelerations. Again, without getting into the details about what's wrong, I don't think that the new guideline has done a very good job in talking about the importance of changes in the variability or the waviness of the fetal heart rate over time, or the significance of some decelerations that are called prolonged decelerations that go on for just too long. So I don't think they've done that properly. And then with respect to things that have been omitted, the new guideline has not included some concerning patterns that were identified in the old guideline in 2007 that no longer appear in the new guideline in 2020. These include biphasic decelerations and decelerations that have a slow return to baseline, or a change in baseline following a deceleration. Now, one of the good things, though, that the SOGC 2020 has done, one of the positive things from the guideline, is that it has allowed a long overdue recognition of the importance of the frequency, the duration, and the depth of decelerations. So the frequency, how many decelerations of the fetal heart rate are occurring, the depth, how deep those decelerations go, and the duration, how long they last, are very important findings about fetal well-being that have not received sufficient attention in old guidelines and certainly need more attention now. So that certainly is a positive thing coming out of SOGC 2020. And if you thought that what I just said is just too technical and dense, wait till you hear what I say about causation. So causation. One might ask, when it comes to causation, one might ask, why is an organization of obstetricians talking about causation when it comes to the injury of newborns? One would have thought that the proper disciplines to assess causation in newborns would not be obstetricians. They don't take care of neonates, but rather neonatologists, pediatricians, pediatric neurologists, and even pediatric neuroradiologists. Why are obstetrical people talking about causation? And the answer, I think, is lawsuits. Because the best defense in some of these lawsuits is causation. Standard of care, often more difficult to defend, but the best defense is causation. And to the extent that the obstetrical community can offer conclusions about causation that might help doctors defend lawsuits, I think the obstetrical community is inappropriately content, and they shouldn't be, because they should have the opposite goal. Their goal shouldn't be to have things that help defend lawsuits. Their goal should be to have guidelines that reduce fetal morbidity and mortality. That should be the objective of everybody. So, having said that, the fact is that the March 2020 SOGC guideline actually talks about causation. And I think it talks about causation in a misguided way. I think they've got it wrong in so many important ways that it's difficult to know where to start. But I will start with something I said in an earlier presentation, and that is causation always starts with neuroimaging. That is, pictures of the baby's brain taken in the first week or so of life using either head ultrasound, CT scan, or MRI will prove that there is no remote antenatal injury. It will prove that there is a peripartum injury, an injury that occurred at or near the time of birth, an acute injury. And it will prove with precision a window of opportunity for that injury to occur. And that window may be as much as a week or 10 days. It could be 2 or 3 days, or the window could be a matter of hours, depending on when the scans of the brain were done and what they show, because we know that these injuries evolve in a well-recognized way from no injury to progress to what we call a reperfusion injury or cerebral edema or brain swelling, and then the swelling resolves, and in its wake, we find that there is damage to either the white matter of the brain, the cerebral hemispheres bilaterally, or the deep gray matter of the brain, or all of the above, depending on the mechanism of injury. There is no recognition in March 2020 SOGC about the importance of neuroimaging in the causation analysis. And in fact, it's my position that if you find that the neuroimaging supports a peripartum injury, then you must look within that window of opportunity, the time interval established by neuroimaging, to find out when the baby was hurt. So that's the starting place. SOGC 2020 completely silent on this important issue. I may add parenthetically that the American College of Obstetricians and Gynecologists, or ACOG, took a look at this issue in 2014, published a rather dense book, I call it the Green Book, and in that book recognized the importance of neuroimaging in the causation analysis, although even ACOG didn't give it the attention it truly deserved. So neuroimaging is key. The other thing that SOGC 2020 misses is the importance of electronic fetal monitoring in refining the timing of injury. Now, what I mean by that is once you establish a window of opportunity for injury by neuroimaging, and let's say it's a matter of days, you can then use all of the clinical events that occurred in that time interval to refine the timing. So you're looking for some event that would explain the bad outcome that you have. And most of the time, it occurs during labor and delivery. If the window is a matter of days, most of the time, it's labor and delivery. And how do you know when it's labor and delivery? And how does EFM, or electronic fetal monitoring, help you narrow the window of opportunity to the interpartum period? And the answer is complicated, but I'm going to simplify it in this way. Where a baby, a term baby, so between 38 weeks and say 42 weeks of gestation, comes into labor with a normal fetal heart tracing, that is, you are entitled to assume that is a baby that is resilient and neurologically intact. Where the fetal heart tracing then over the course of labor converts from a normal tracing to a tracing that is either atypical, and I won't get into the definition of atypical, but I can for those of you who wish to speak to me later, or abnormal, and then the baby is born in a depressed condition, that is a baby that's hurt during labor. Unless there is some other clear and obvious clinical event that occurred in that time interval that would reasonably explain the injury seen on neuroimaging, the only reasonable conclusion one can have is that the injury was interpartum. This is rock solid. This is something that we have to understand. And I make this point because of my next bullet on this slide, which is where the guideline refers to other clinical variables as being required to establish causation. For example, multi-organ injury. So the SOGC guideline for 2020 says that unless you have multi-organ injury, you didn't have an interpartum brain injury. Multi-organ injury being usually liver, kidney, heart, or gut, usually. You need to find some injury to other organs in order to prove a connection between labor and delivery events and a neurological injury to the newborn. That is simply not the case. It's often present. It may well be present. And the process by which babies get injured often result in multi-organ dysfunction, by the way, not injury as they describe, but rather dysfunction. So it is a transient impact on, say, kidney function, where you'll have reduced urine output typically. Elevated creatinine because of kidney involvement. And that often happens. But if it's absent, it does not disprove that the injury occurred during labor and delivery. A very important point to make. And there are many reasons why that's the case. When a baby is born, the umbilical cord is clamped and samples of blood are taken from the cord. And the samples of blood will also tell us a lot of information about how well oxygenated the baby was immediately prior to delivery. SOGC 2020 says that analysis of cord blood has to show a pH of less than 7.0, or there's no connection between the newborn injury and labor and delivery events. That's just not true. Well, it's true that many babies injured during labor and delivery have a cord blood pH in the artery of less than 7.0. It isn't mandatory. It occurs that where babies have a cord blood pH of 7.1, even as high as 7.2. This is another matter that ACOG addressed in their 2014 guideline that for some reason SOGC 2020 chose to ignore. Same thing is true of something called the base deficit, BD, base deficit, sometimes referred to as the base excess, where SOGC 2020 says if it's not 12 or higher, injury wasn't caused during labor and delivery. Not so. As well, in SOGC 2020, there's a list of 12 findings that one would expect to be associated with what they call fetal hypoxia. Now, I'll say two things about it. Number one is that no, not all of these things are present. They may be, some of them may be, one or more may be, but they're not always present. Number two is, and this is an important, though technical distinction, is that the issue is not fetal hypoxia, it's ischemia. These are two very different events. Between hypoxia and ischemia is the most important thing. Ischemia is what causes injury to organs, particularly to the brain. Ischemia being a lack of oxygen supplied to the tissues. Some other, I think, careless things that SOGC 2020 says is that only babies that are vulnerable get injured in labor, and that's not the case. The babies that come into labor who are resilient can nevertheless be injured by the mismanagement of labor by nurses, doctors, and midwives. I've already talked about the distinction between hypoxia and ischemia, which is important. And then I think in a very imprecise way, SOGC talks about two types of hypoxia in labor. One they call acute, and the other they call chronic. Well, they're both acute. Chronic hypoxia is something that's quite distinct. I think that what SOGC 2020 was trying to distinguish was the difference between babies who suffer their injury over a prolonged period of time, but during labor, called a prolonged partial hypoxia ischemia, or babies that suffer a very sudden injury during labor, usually caused by something called a sentinel event. So sentinel event would be rupture of the uterus, a severe hemorrhage by the mother, a placental abruption, or a prolapsed umbilical cord. So again, very imprecise about that sort of stuff. So to the extent that your experts are relying on SOGC 2020 for an opinion on causation, they ought not to, because it is not authoritative by any stretch on the issue of causation. So in this slide, I'm talking about the SOGC perpetuating some old thinking that I say is not supported by the science. I've already talked about my view that intermittent auscultation is never superior to electronic fetal monitoring and shouldn't be used even in low-risk labors. I don't believe that the data that the guideline relies upon to come to that conclusion is reliable, but it is a conclusion that is promoted by most obstetrical guidelines, both here in the United States and in Europe. I said earlier that one of the reasons why EFM isn't promoted by some people is that they believe that there are too many cesarean deliveries associated with EFM. And even if that were true historically, the use of EFM in the last 10 years or so has really changed quite dramatically. The technology is different. The training is different. I don't think that additional research properly conducted now would support that conclusion. One of the reasons, as I said earlier, that EFM is criticized is because there has not been an improvement in fetal outcomes. Now, that literature, too, is seriously flawed. First of all, it's grossly underpowered. The children who are injured during labor is such a small number of kids that you would need an enormous cohort of people in order to test out the hypothesis. But the more important thing is the literature that suggested that EFM doesn't improve fetal outcomes is literature that looks at only one outcome, and that is cerebral palsy. It's very important for you to understand that cerebral palsy is not the only adverse outcome that follows from birth asphyxia. Cerebral palsy is a motor disorder. Not all babies who suffer neurologic injury in labor suffer a motor disorder. They may have a brain injury where they have good motor function, but they are left with developmental problems, cognitive problems, behavioral problems, autistic-like symptoms. These things happen in these babies. And so if a study that evaluated the benefit of EFM based on the rates of cerebral palsy were relied on, they've asked the wrong question. Because the issue isn't cerebral palsy. The issue, rather, is a depressed neonate, so something called the neonatal encephalopathy. There are studies that have demonstrated that the incidence of neonatal seizures is reduced using EFM, and also that neonatal death is reduced using EFM. And it's my view that a properly conducted study would support the idea that seizures are reduced using EFM and death is reduced using EFM, and probably neurodevelopmental problems are reduced using EFM, because as I said, CP is not the only measure of bad outcomes. So that anybody who advances the notion that because cerebral palsy rates have not diminished over time, therefore EFM, which is ubiquitous, is of no benefit, the conclusion simply does not follow from the data. None of the studies that are cited by SOGC 2020 are robust enough to support that conclusion. The other important point is that the shortcomings of intermittent auscultation are completely ignored in SOGC 2020. And what are those shortcomings? Well, the fact is that the fetal heart rate is listened to for only a minute following contractions. That means that anything that occurs during a contraction, and there can be decelerations during a contraction, anything that occurs during a contraction will be missed. And decelerations, particularly decelerations that are associated with cord compression, are important for fetal oxygenation. So if you miss a deceleration during a contraction because you're using intermittent auscultation, you may be missing important data about how well this baby is coping with the stress of labor. Likewise, you can't assess variability of the fetal heart rate using intermittent auscultation. So that is the waviness of the baseline around, or the waviness of the heart rate around the baseline. When that waviness is reduced, it's an indication potentially that the baby is hypoxic or short of oxygen. And you cannot make that determination using intermittent auscultation. With intermittent auscultation, there's no opportunity to verify the skills of the operator. With EFM, you can actually see whether they properly evaluated the tracing. With intermittent auscultation, you just have to take them at their word, what they recorded in the chart. And how does one explain good findings on intermittent auscultation and a baby who's born depressed? Either the intermittent auscultation was done improperly, which we can't verify, or the person wasn't skilled in doing intermittent auscultation. I've already talked about inter-observer variability in the interpretation of the fetal heart rate, and I just want to emphasize that those studies all asked the wrong questions. They were poorly designed. They did not take into consideration the overall clinical picture. And one thing I can commend about SOGC 2020 is that repeatedly through the guideline, they recommend an assessment of the overall clinical picture. They just don't tell us how to do it properly, but they recommend it. And had the studies that looked at intermittent or looked at inter-observer variability with EFM done that properly, they would have recognized that their studies were flawed, and people should not be relying on their studies to diminish or undermine the benefit of EFM. I've talked about CP, and I've talked about the fact that SOGC 2020, while it cites the ACOG publications, and incidentally, there are two ACOG publications. One was in 2003, and it was changed in 2014 rather dramatically. What SOGC 2020 has ignored are the changes between the 2003 version of ACOG's Green Book and the 2014 version of ACOG's Green Book. There are some very important changes that for some reason SOGC has decided to ignore. There are some things that they rely on in SOGC 2020 from ACOG, but nothing that is meaningful on the issue of causation, and certainly nothing that's meaningful on the issue of standard of care. So let's talk about literature generally, even though I'm talking about obstetrics. It's important for us as advocates for our clients to know the difference between junk science and reliable literature. And obstetrical literature is riddled with junk science, something that we need to understand. But as well, even with reliable literature, we must take a hard look at that reliable literature and ask, does it apply to the clinical circumstances under which our clients find themselves? Because often it doesn't. If we tease out some variables, you may find that the literature helps your case rather than hurts your case. And sometimes the experts don't spend enough time doing this. The other thing is our experts may rely on this flawed literature. You've got to be prepared to take them on if they rely on the flawed literature. It's not easy. It means that you've got to be tuned into this flawed literature. So we need to take a critical look at all of these cases because there really is so much at stake for our clients. So what needs to be done, in my view, is that SOGC needs to go back to the drawing board. I think that it's high time that we address these issues, that we address the shortcomings in the literature, not for the purposes of us as litigators, but for the benefit of the unborn. The fact is that the best defense to medical legal claims are improved neonatal outcomes. And I think that I don't care what side of the lawsuit you're on, I think that we are all consumers of healthcare and we all have families and we want to promote improvements in both neonatal mortality and morbidity. It's essential that we do that. The failure to improve these outcomes is a cost to our healthcare system that is huge. It's very costly to our tort system. The biggest payouts from CMP and HIROC would be on baby cases, babies injured in labor, particularly babies with cerebral palsy. And it creates an intolerable burden for the families affected by these cases. So I apologize for the technical nature of my talk, but as I said when I started, that you can take this talk and you can apply it to any literature. It doesn't matter what the literature is. You can apply it to anything. And it's incumbent upon us as advocates to truly advocate, to not rely on nurses and doctors and third parties to advance our clients' interests, but to take a hard and critical look at the literature, at the opinions, and to promote cases that are meritorious and to drop cases that aren't. But before we drop those cases, we have a duty to our clients to make sure that we've done the job. So again, sorry for the technical stuff and thank you for listening. I hope that helps some of you. And thanks for being there.
Wow, what a conference. Well, we can't thank you enough for taking the time out of your day to join us for our second annual Risky Business Conference. With all of the virtual meetings and events that have been happening in the last several months, I'm sure many of us are getting a bit fatigued with logging in for another online meeting. But as we're confident that our online speakers and topics would be of tremendous value to many of the legal, medical, and rehab communities, for those looking to expand their knowledge around medical negligence. These are tough cases, and there's much to learn about how to manage them. After a successful event last year, we are very excited to offer this again this year. Had things worked out differently, we would have been welcoming most of you in person in Niagara. But with things around us changing so rapidly, we made the decision to take our event virtual. This has actually provided a great opportunity to open the event on a bigger scale. And we've had probably close to 300 people today. And this has given us a chance for many of the attendees to join us, and also from all over Canada. Thank you all for our presenters, for sharing their time and expertise, for being so accommodating with our need to take things fully online. We couldn't have made this a successful day without everybody contributing and being committed to this. And again, to all of you, thank you for joining us. The event has been recorded, and we will make it available to everyone on our YouTube channel to watch and share in the future. We hope to see you again next year.
Yeah, I just want to add, thank you very much for attending from far and wide. We've reached a bigger audience than we ever hoped, and hopefully you'll stay in touch with us. We will be hopefully sending out a survey to find out what could be improved and what went well and didn't go well. And anyway, we enjoyed it. We enjoyed the speakers and the content they have. We hope that you got a lot out of that as well. There is CPD credit, which is available, and on our website, it'll show you how to get that credit. And just please keep in touch with us. Let us know what other topics you're interested in. And we hope that this has been of value to you. So thanks again for joining us and being part of our session today.